Robin did.
Sorry.
All in favor say aye.
Aye.
All opposed? Motion carries unanimously. Do I have a motion to approve the minutes for March 14th, 2024?
Motion to approve minutes for March 14th, 2024 as written.
Do I have a second? I'll second the motion. All in favor say aye.
Aye.
All opposed, nay. Motion carries unanimously. In accordance with the State Government Ethics Act, it is the duty of every board member to avoid conflicts of interest. Does any board member have any known conflict of interest with respect to any matters coming to the board tonight? If so, please identify the conflict and refrain from any participation in the particular matter involved.
No?
None here.
Hearing none, we have no disqualifications. Old business, item 1, Board of Adjustment 22-01, Mr. Young, public hearing. This is a limited purpose hearing to hear evidence on the specific section 10.4.1.d parentheses 2 in parentheses of the Unified Development Ordinance for determining whether the petitioner's unlisted use of operating an automobile rentals business on residential property located at 1086 Hampton Street, Corolla, tax map 115B as in boy, parcel 563, Poplar Branch Beach Township, was similar or dissimilar to a prohibited use in such zone. Anyone wishing to speak tonight, may we have you come up and be sworn in, please? Are you planning on testifying as well?
No, he's not.
Okay. All righty. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You may be seated. And how would you like to proceed? Would you like to make a synopsis about our purpose tonight, or would you like me to do that?
Sure. So I think this has been on the agenda a few times. I think we all know why we're here tonight. This is on remand from an appeal to Superior Court. This is on remand from the Honorable Judge Tillett. In regards to his order, he gave this board a couple options on how you can address this remand, and you voted to hold a limited hearing for these factors, which is one of the options he gave in his order. And so I think that at this time it would be appropriate to start with the county, and then certainly Ms. Young's counsel can cross-examine, have questions. I think we still follow the same procedure. It's a little unusual. We don't normally do this, and I don't think since I've been representing the board we had a remand. So I think that we'll start with the county, and we'll follow the same type of procedure we would if we were having a full
Public hearing.
full hearing. So I think we can tender it to the county and go from there.
All right. Thank you so much for that synopsis. Are the county ready to proceed?
Yes, Mr. Chairman, thank you. I would request that I give just a brief opening statement to the board as kind of a summary. Your attorney did an excellent job, but I would request to give just a brief opening statement to summarize what's going on, if you're okay with that. Okay.
Opposing counsel object or no?
No objection.
Okay, go ahead.
Make sure. Okay, so I know we've been here, this is probably like the fourth time that we've been before you on this matter, so you're very familiar, but just in case, Misty Young owns the property located at 1086 Hampton Street in Corolla. That is zoned single-family residential Outer Banks, also known as SFO, and within the Corolla Light planned unit development, which designates the property for residential use. In 2022, the county received complaints that Ms. Young was operating a Jeep rental company from her property. Ms. Young operates what she calls car sharing through an online platform called Turo. Using the proper UDO standards, county staff determined this use was most similar to automotive sales and rentals because our UDO does not have car sharing as a listed use. And automotive sales and rentals is prohibited in that SFO zoning district. And so they issued a notice of violation. This board affirmed that violation, which was appealed to Superior Court, which Ms. Womble noted that the Superior Court remanded it back to you all so that there could be findings on, there's 13 factors that the county considers in determining whether an unlisted use is similar to a listed use. So we're going to go over those 13 factors with you today.
Before you get started on the 13 factors, can you talk a little bit about the notice of violation that was issued to the applicant? Like, what was remind us of what the basis of that notice of violation was?
Sure, and I have a copy that I could hand out if you would also like
Yeah,
to
that
have
would
the
be- that would be
original
great.
notice of violation.
Yeah.
Yeah, there should be. I think, is that 5? You might want 6 so that you can have a copy as well.
And Mr. Cook, did you guys care to do any opening now? You want to defer till you make any sort of presentation or?
No, we have no opening, but we will do a closing.
Okay. And I didn't catch your name, and I'm referring to him, Mr. Cook, because he's the only one I've dealt with, and I'm not trying to be rude. So,
No, no worries. My name is Marie Farmer.
Farmer?
Yes.
Okay, wonderful. Thank you.
So if you'll notice in this original notice of violation that was issued, well, the violation date was March 2nd, 2022. The violation description notes that automotive rentals are being conducted without a special use permit at 1086 Hampton Street in Corolla Light Planned Unit Development. The subject property is zoned SFO with PUD overlay and designated for residential development. In the most recent approved sketch plan for the PUD, automotive rentals are not permitted to be operated from this property.
And so just for the record, so we know what's being put on the record tonight, what's evidence, because depending on which way this goes, one of the two of you will likely take this back to Superior Court. So I think that it'd probably be appropriate to go ahead and have staff identify this just for the purpose of this is where this case originated from, not getting the weeds since we are here on the factors. I believe this is already in the underlying record, which is part of the board's record in this anyway. But I just want to make sure we're getting it in on the record in evidence under sworn testimony.
Yeah, I agree. Yeah.
If that's okay, we can go ahead and proceed with that, and then if you want to have staff identify it for that purpose, and then you can begin your presentation, and then the board can ask questions from there.
Good to me.
I call Jenny Turner to the stand.
Sheree, do you have the clicker? PowerPoint? I don't need it necessarily, it just still says welcome to the meeting. I don't know if we had a slide.
Can you state your name and how you are employed?
My name is Jenny Turner. I'm the Assistant Planning Director.
And what's your educational background?
I have a degree, a Bachelor of Science degree in Business Management from North Carolina State and a minor in Mathematics.
And what's your employment history?
I've worked with the county since August of 2009, started as a code enforcement officer, was promoted to Planner 1, then Planner 2, then Senior Planner, and most recently to Assistant Planning Director.
And what are your duties and responsibilities in that position? As Assistant Planning Director?
Well, they're generally the same as Senior Planner with some more supervisory responsibilities, but to enforce the ordinance, assist the community and citizens with questions regarding the ordinance, process zoning applications, special use permits, assist with code enforcement as needed, planning items, site plan review, rezonings, text amendments, land use plan amendments. That's a lot of what I do.
Are you familiar with the matter before the board tonight?
Yes.
And what has been your involvement in this matter?
I originally assisted our code enforcement officer, Anna Cherry, in determining and responding to the complaint and understanding the ordinance as it relates to the violation. And then I testified at one of the hearings.
Okay. May I approach the witness?
You may.
Okay. And I'm handing her the notice violation, which you all have. Did you get one of them? Did you get one of those? Okay, Ms. Turner, is this the notice of violation that was issued to Ms. Young? And this is the main issue that's before the board?
That's correct, yes.
Okay, I move to introduce this notice of violation number 1708 into evidence as County Exhibit 1.
So
Or A?
let's do county remand 1.
Okay.
That
Keep it
way
all
we
straight.
know the difference
Yeah.
in the record.
Okay.
And we'll do the same if Ms. Young's counsel has any exhibits.
Okay. So what is your understanding of the purpose as to why we're here tonight regarding this matter?
My understanding is that the purpose is to review the 13 standards of the ordinance, section 10.4.1D2.
And is that just part of how county staff determines whether a unlisted use is similar to a listed use?
That's correct, yes.
Okay, and looking at those factors, does the county have to consider every single one of those factors?
The ordinance does require that, that all those factors are considered. Yes.
Does it only require the relevant factors to be considered?
All relevant characteristics of the use.
Okay, so can you just walk us through the factors that county staff deemed relevant and considered in making their determination that car sharing is similar to automotive sales and rentals?
Sure, I can do that. We can start with A, the volume and type of sales, retail, wholesale, et cetera. Generally, and I believe the violation shows that there were about 3 vehicles initially when the first notice of violation was sent, which for automobile sales and rentals would typically be considered low volume. But the type of sale is a commercial sale, which was the exchange of money for rental. Sales is the action of selling something or the exchange of a commodity for money. The size and type of items sold and the nature of inventory on the premises. We know it was vehicles that were, and the rental of the vehicles was the sale, and the vehicles were stored on the premises at the time at 1086 Hampton Street. C is any processing done on the premises, including assembly, manufacturing, warehousing, shipping, distribution. That did not appear to be applicable to the use. D, any dangerous, hazardous, toxic, or explosive materials used in the processing. Again, did not appear to be relevant. E is the nature and location of storage and outdoor display of merchandise, whether enclosed, open, inside or outside the principal building. Predominant types of items stored, such as business vehicles, work in process, inventory and merchandise, construction materials, scrap and junk, and raw materials, including liquids and powders. The nature and location of storage on this property was storage of vehicles, and the vehicles were stored, based on the pictures, the vehicles were stored in the driveway and adjacent to the driveway. And initially, they were the vehicles that were offered for rental on Turo, as well as other vehicles on the property. F, the type, size, and nature of buildings and structures. The property at 1086 is a residential property with an existing single-family dwelling on the property. G, the number and density of employees and customers per unit area of site in relation to business hours and employment shifts. The Turo website, I don't know if there were hours related to that specifically, but this particular provision did not appear to be something that needed to be considered with determining whether there were rental of vehicles taking place on the property. H, transportation requirements, including modal split for people and freight by volume type and characteristic of traffic generation to and from the site. For vehicles, transportation requirements are roads, vehicles. Modal splits would generally refer to walking, biking, vehicular, public transit, rail, ferry. That did not seem to be applicable to the use. I, trip purposes and whether trip purposes can be shared by other use types on the site. Trip is a one-way journey that proceeds from an origin to a destination via a single mode of transportation, basically exiting and entering a property. And the purpose of the trip is the main activity at the destination of the trip. The trip purposes for this use were for rental of vehicles. I think I'm at J. Parking requirements, turnover, and generation ratio of the number of spaces required per unit area or activity. The parking requirements, I mean, the vehicles are vehicles, so they need to be parked on the property. At the time, it wasn't clear if customers were actually coming to the property to pick up vehicles, if they would need to be parking as well. K, the amount and nature of any nuisances generated on the premises, including but not limited to noise, smoke, odor, glare, vibration, radiation, and fumes. There did not appear to be any nuisances of that sort based on the use that was being operated from the property. L is any special public utility requirements for serving the proposed use type, including but not limited to water supply, wastewater output, pre-treatment of waste, and emissions required or recommended in any significant power structures and communication towers or facilities. Did not appear to be relevant. And M, the impact on adjacent lands created by the proposed use type, which should not be of greater than that of other use types allowed in the zoning district. Uses in the single-family Outer Banks residential zoning district in the summary uses table are generally residential or institutional, with very few commercial uses permitted in the zoning district.
Sorry. And in looking at those factors, what did county staff, what was the ultimate determination as far as if the car sharing use was similar to automotive sales and rentals?
It was deemed to be automotive rentals.
And I move to introduce the section of the UDO that Ms. Turner was testifying about, 10.4.1 D2, into evidence as County Remand 2.
Mr. Chair, would you accept 1 and 2 for the record?
Yes.
Okay, I have no further questions.
All right, we'll let Ms. Farmer proceed, and then we'll circle back to the board after that.
Good evening, Attorney Farmer.
Yes, good evening.
Go
Chair
ahead and
Craddock.
proceed. You or Attorney Crook, either one.
Yes, thank you. And good evening, Ms. Turner. As you had alluded to during your testimony, there are several sections of the EDO that govern the procedure for the interpretation of unlisted uses, and those are found in chapters 2 and 10. Is that right?
Probably, but are you talking about the interpretation section?
Yes, there's several places in the UDO that govern the interpretation of unlisted uses, is that right?
Yes.
But the section specifically at issue for this hearing is section 1041D2.
Yes.
And that section is entitled Standards for Interpreting Unlisted Uses as Permitted. Is that correct?
That's correct.
And that is the only section that is highlighted in the agenda packet for this evening, right?
Correct.
And that section of the UDO, it contains 13 characteristics for determining whether an unlisted use is so similar to a listed use that is allowed in the zoning district that the unlisted use should be allowed in the same manner. Is that correct?
Did you read that from the ordinance?
I'm happy to read it. If you have it in front of you, if you could read silently, I'll read aloud. The director shall interpret an unlisted use as permitted in a particular zoning district only after determining that the nature, function, and duration of the use and impact of allowing it in the zoning district are so similar to those of a use type or use category allowable in the zoning district that the unlisted use should be deemed allowable in the same manner as the similar use type or use category. Did I read that correctly?
Yes.
Okay.
Except for you didn't say land use, but that's fine.
Which part?
You didn't say unlisted land use, you said unlisted use.
Sorry, unlisted land use. But other than that, that was the correct reading of that section?
Correct.
And to prohibit a use, you also look to the 13 characteristics in 1041D2, but you use section 1041D3. Is that correct? And that section is entitled Unlisted Use Not Permitted. It is right below. Is that the section for?
Yes.
Okay. And this section provides that if a proposed unlisted use is not similar to a listed use, the proposed use shall be prohibited. Is that correct?
Yes.
Now, peer-to-peer vehicle sharing or car sharing is not a use type identified in the use table in the UDO, right?
Not the way you're describing it, no.
Well, at all. Peer-to-peer vehicle sharing, those words,
That's
peer-to-peer
correct.
vehicle
They're
sharing.
not
or
in
car
the
sharing.
ordinance.
Okay.
Yeah.
And it's not defined anywhere else in the UDO, is that correct?
That's correct.
Now, you compared this unlisted use of car sharing to the listed use automobile sales or rentals. Is that correct?
Correct.
And that use is not permitted in the Single Family Residential Outer Banks District, or SFO.
Correct.
That is the zoning for Miss Young's home at 1086 Hampton Street in Corolla.
That's part of the zoning, yes.
There's also an overlay
Yes.
that's applicable. But regardless, the car sharing is not a permitted use in the SFO with the overlay.
Correct.
Now, automobile sales or rentals is defined by section 10.5 of the UDO as.
So we're getting a little out of the realm of where we're supposed to be. We're here on the factors, and we're not here to argue about whether peer-to-peer. The board already determined that they affirmed staff's decision. We're here on remand for additional findings for this reason, not whether peer-to-peer is defined somewhere. So tell me where this is connecting to the factors.
Yes.
And their determination, because that's what we're here for.
So those 13 factors are to look at the unlisted use, which in this case is car sharing, and compare it to the listed use, in this case automobile sales or rentals. So there's a comparison that needs to occur between the unlisted use and the listed use. So right now we just want to establish with Ms. Turner what the unlisted use was and what the listed use was, so then we can go through those 13 characteristics.
So I think that you're going backwards too much, because the board's already been through that section. We weren't going back through what the purported unlisted use versus, we're only here on their determination for these factors. So if you're going to go back that far, then the county's got to go back that far. The board has to go back that far. The board has to go back and review their record that far. And that's not what the purpose of tonight's hearing was.
The only question that I was about to ask Ms. Turner was simply what that definition of automobile sales or rentals is, which is important in looking at those 13 characteristics, so we know what the definition of the use that we're all talking about. is, and then simply what an example of that type of use would be. Because again, the 13 characteristics is looking at what Ms. Young did at her home, and then what that typical automobile sales or rentals use would be, using those 13 characteristics to
Well,
compare
I
the
think
two.
you can ask Ms. Turner about the definition that she arrived at, which was already I think the last question by the county. And then I think you need to focus on the factors, because you're getting into the legal weeds, which we've already been through, which the board is not here to reconsider tonight.
I will just ask what the definition of that use is, how the county interprets that, and then we will get right into the 13 characteristics. That is okay with the board?
Yep.
Okay. So, Ms. Turner, automobile sales or rentals is defined by Section 10.5 of the EDO as premises on which new or used passenger automobiles, trailers, recreational vehicles, or trucks in operating condition are displayed for sale, lease, or rental. Is that correct?
Yes.
And so, based on your interpretation of this, what is an example of a typical use that would fall under the automobile sales or rentals use?
A use that's renting vehicles or selling vehicles.
So would that be like a Hertz or an Enterprise?
It would be any use in the county that's renting vehicles. So it wouldn't be just like a Hertz or Enterprise.
But is that the typical use that you would associate with this?
I'm not sure that we have that use in the county. So no, that would not be typical in the county. We have issued some special use permits for rental of classic cars, which was a very low number of cars that were permitted.
So there is no typical use that the county was looking at when comparing Ms. Young's use to the automobile sales or rentals?
Well, you just read the definition, and it says it's premises on which new or used vehicles basically are displayed for sale, lease, or rental. So that's what it is.
So you compared Ms. Young's use just looking at that definition?
Well, we're here to talk about the 13 factors,
Yes, well, let's
Right.
get into
which is
those.
more than the definition.
So let's get into those 13 characteristics. Those are in UDO section 1041D2, and we're looking again at that section as they relate to the peer-to-peer vehicle sharing or car sharing that Ms. Young did at 1086 Hampton Street in 2022. So the first is the volume and type of sales, retail, wholesale. This was a factor that the county found relevant in its analysis.
The volume and type of sales, yes, relevant.
And so could you describe the volume and type of sales, retail, wholesale, et cetera, for a typical automobile sales or rentals use?
Well, it was for a typical automobile sales or rentals use. Yes, that would be either selling straight up retail sales of a vehicle or renting a vehicle and receiving a fee for the rental. That would be typical.
Now, you mentioned that what Ms. Young was doing was at a lower volume than what might be typical. So with the typical automobile sales and rentals, that would be at a higher volume typically?
It could be at a higher volume. Yeah, I'm sure sales generally in the county have been at a higher volume.
And as you had said earlier, you would describe the volume and type of sales for Ms. Young's car sharing with Turo a lower volume.
Initially, yes, when we sent the violation for the 3 vehicles that were shown on Turo.
And so how is this similar to the typical automobile sales or rentals use?
Because the vehicles were being rented for money, for payment, for a period of time, and stored on the property.
And just to be clear, according to the county's interpretation, rentals were occurring. There was no sales that were occurring, right?
That's correct.
Now,
That's our understanding. I don't know if there were sales. Maybe there were.
there was no evidence the county had
Correct.
that she was selling. Now, the second characteristic is the size and type of items sold and the nature of inventory on the premises. You found this characteristic was not relevant for the county's analysis, right?
Did I say that?
I believe so. If not,
No, I think I said that there were vehicles, and the sales are rentals of vehicles.
So the county did use this characteristic in its
Right, and the
analysis.
vehicles are stored on the property.
And so could you describe the size and type of items sold and nature of inventory on the premises for a typical automobile sales or rentals use?
So it would be a vehicle that would then be rented for payment for money, in exchange for money for the use of the vehicle for a certain time frame, and generally returned to the property.
Would they be personal vehicles or would they be owned by potentially a company or a business?
What do you mean?
Would they be vehicles that are owned and registered by someone in their individual capacity, or would they be vehicles that would be owned by an entity, a business?
It could be either.
Okay. So could you describe the size and type of items sold and nature of inventory on the premises for Ms. Young's car sharing through Turo at 1086 Hampton Street in 2022?
Based on the violation, there's a picture of the Turo website that shows a Gladiator and 2 Jeep Wranglers. So a Jeep Gladiator and 2 Jeep Wranglers.
And those were Ms. Young's personal vehicles?
They were vehicles that were on the Turo website for rental.
But they were.
You'll have to ask Ms. Young if they were her personal vehicles. I think she stated previously that they were her personal vehicles.
So in looking at the items sold and nature of inventory, the county didn't look at who owned the vehicles in looking at that characteristic?
The nature of inventory is it's a vehicle.
Okay.
Ownership is not generally something that we can regulate in zoning.
And so how is this similar to the typical automobile sales or rentals use, what Ms. Young was doing?
She was renting vehicles and calling it car sharing or peer-to-peer vehicle sharing. She was providing a vehicle in exchange for the use of a vehicle in exchange for money.
Okay. The third characteristic is processing done on the premises, including assembly, manufacturing, warehousing, shipping, distribution. You found that this characteristic was not relevant, is that correct?
Right.
The fourth characteristic is any dangerous, hazardous, toxic, or explosive materials used in the processing. This characteristic was also not found to be relevant
Correct.
in your analysis.
Right.
The fifth characteristic is the nature and location of storage and outdoor display of merchandise, whether enclosed, open, inside, or outside the principal building. Predominant types of items stored, such as business vehicles, work in process, inventory and merchandise, construction materials, scrap and junk, and raw materials, including liquids and powders. And the county did use this characteristic in its analysis, correct?
Correct.
So could you describe the nature and location of storage and outdoor display of merchandise for a typical automobile sales or rentals use?
Well, vehicles are stored on the property for sale or rental.
Are they usually lined up in a row or some other arrangement facing the street?
I suppose they're sometimes lined up in a row.
And could you describe the nature and location of storage and outdoor display of merchandise for Ms. Young's car sharing through Turo at 1086 Hampton Street in 2022?
Yes, and as seen in the pictures, it's vehicles that are parked. One appears to be in the driveway and 2 appear to be adjacent to the driveway.
And how did Ms. Young have her vehicles displayed for sale, lease, or rent?
You could see them on the property.
So how did the county assess that they were displayed? Just how
Because they were
parked?
shown on the Turo website as available for rental and they were on the property.
Did the county look at how the cars were parked on the property in making that determination?
We looked at the fact that the cars were parked on the property.
Now, you referenced the pictures in the notice of violation. Those pictures submitted and put in the notice of violation, they show Ms. Young's cars facing her home and not facing the street. Is that right?
That's correct.
Is there any evidence that Ms. Young ever parked the vehicles lined up in a row facing the street like you would typically see with a Hertz or an Enterprise?
I'm unsure if there are pictures that would show that.
So if someone were driving by Ms. Young's home and saw her cars parked like you see them in the notice of violation, in her driveway, they wouldn't know just by looking at them that they were available for rent, right?
Objection. I don't think she can testify to what other people would know when they ride by the property.
Objection sustained.
When you look at these pictures and you see them parked in this manner in the driveway, would you know just by looking at them if they were available for rent?
I wouldn't know, no. But I did know because they were on the website.
But you only knew because they were on the website, right? Not just by looking at them parked in the driveway?
Right.
Did Ms. Young have signs on her property indicating the vehicles were for sale, lease, or rent?
I do not know.
Did the vehicles have any sort of stickers, wrap, or writing on them to indicate they were available for sale, lease, or rent?
I do not know.
Did Ms. Young have lights illuminating the vehicles to put them on display?
I don't know.
So how are the cars parked here in the driveway as shown on the NOV similar to the typical automobile sales or rentals display?
There are vehicles stored on property for rent.
And those are the only similarities?
I don't know.
Could you describe the predominant types of items stored for a typical automobile sales or rentals use?
Vehicles.
And could you describe the predominant types of items stored for Ms. Young's car sharing through Turo at 1086 Hampton Street in
Vehicles.
2022?
Yeah.
So the only similarity is that they're vehicles.
Vehicles that are proposed for sale or rental on Turo website.
Now, the sixth characteristic is the type, size, and nature of buildings and structures. You did use this characteristic in your analysis, right?
Yes, it's a residential home, single-family dwelling.
Could you describe the type, size, and nature of buildings and structures for a typical automobile sales or rentals use?
Say that again?
Could you describe the type, size, and nature of buildings and structures for a typical automobile sales or rentals use?
Well, generally, there would be potentially a storefront.
Could you describe the type, size, nature of buildings and structures for Ms. Young's car sharing through Turo at 1086 Hampton Street?
Yeah, there didn't appear to be any structures.
So there were no structures?
It didn't appear to be any structures related to rental of cars, no.
And so there was no similarity between Ms. Young's car sharing and a typical automobile sales or rentals use based on the nature of buildings and structures, correct?
Correct.
Now, the seventh characteristic is the number and density of employees and customers per unit area of site in relation to business hours and employment shifts. The county, or you also did not find this relevant for your analysis, correct?
Correct.
And is that because Ms. Young does not have any employees?
We weren't aware if she had employees or not, but she had her vehicles listed for sale on the Turo website, or for rent rather, on the Turo website.
And so because you didn't know for what Ms. Young was doing, there was nothing to compare between Ms. Young's activities and a typical automobile sales or rentals, right?
What? There was nothing to compare with respect to?
You said that you were not sure if Ms. Young had employees. So you
Right.
did not compare Ms. Young having employees or not having employees with the number and density of employees and customers
Yes,
per unit.
that's correct. Yeah.
Now, the eighth characteristic is transportation requirements, including the modal split for people and freight by volume type and characteristic of traffic generation to and from the site. You did use this one in your analysis, is that correct?
I just mentioned that their vehicles and that transportation requirements would be, roads for vehicles.
Could you describe the transportation requirements and traffic generation for a typical automobile sales or rentals use?
Well, that would certainly vary depending on the number of vehicles the size of the park. There would be too many variables to do that.
Could you describe the transportation requirements and traffic generation for Miss Young's car sharing through Turo at 1086 Hampton Street in 2022?
She's renting 3 vehicles.
Those were the transportation requirements and traffic generation?
Right. I mean, there are 3 vehicles that to rent would have to be driven off the site.
And how is that similar to the typical automobile sales or rentals use?
Because you rent a vehicle and you drive it off the site, or you have it delivered to you.
And are those the only similarities?
Similarities of what?
The similarities between Miss Young's 3 vehicles and the typical automobile sales or rentals use?
I don't understand your question. The only similarities between her vehicles and a typical automobile sales and rental, it's just too ambiguous. What are you asking me?
We're looking at the 8th characteristic, which is the transportation requirements and
Okay.
traffic generation. And you said Miss Young had 3 vehicles, and you said that for the typical automobile sales or rentals use, it would vary. So I'm just asking, how are those, what Miss Young was doing, and the typical, how is that similar? Were there any other similarities?
I'm not sure.
Okay. The 9th characteristic is trip purposes and whether trip purposes can be shared by other use types on the site. The county did use this in its analysis, correct?
I said what trips were, but I don't know if I said that we used that in the analysis.
So did the county use?
No.
No. Okay. The 10th characteristic is parking requirements, turnover, and generation, ratio of the number of spaces required per unit area or activity. Did you use this characteristic in your analysis?
No, I don't believe so.
The 11th characteristic is the amount and nature of any nuisances generated on the premises, including but not limited to noise, smoke, odor, glare, vibration, radiation, and fumes. I wrote down that you testified earlier that there were no nuisances, so you did not use this in your analysis?
Correct. Well, I mean, saying no nuisances means we didn't use it.
Okay.
I don't know. I think it means that we considered it and said it didn't apply.
Okay. So you did not compare what Ms. Young was doing and a typical automobile sales or rentals in terms of nuisances?
It didn't seem to be relevant because she was renting vehicles from her property.
The 12th characteristic is any special public utility requirements for serving the proposed use type, including but not limited to water supply, wastewater output, pretreatment of waste, and emissions required or recommended, and any significant power structures and communications towers or facilities. This was a characteristic that you also did not find relevant and did not use, correct?
Correct.
And the 13th characteristic is the impact on adjacent lands created by the proposed use type, which would not be greater than that of other use types allowed in the zoning district. And you did use this characteristic in your analysis, correct?
Correct.
Could you describe the impact on adjacent lands created by typical automobile sales or rentals use?
There could be some lighting, some additional traffic.
And you testified earlier you weren't aware that Ms. Young used any lighting on her property, correct?
Correct.
Could you describe the impact on adjacent lands created by Ms. Young's car sharing through Turo at 1086 Hampton Street in 2022?
I think that I just mentioned that uses in that zoning district are generally residential or institutional, and there are very few commercial uses permitted in that zoning district.
But what, if any, activity was Ms. Young doing that could have had a potential impact on adjacent lands? Was there any that the county looked at?
I don't know that I have anything specific for that.
Okay. And so you did not compare Ms. Young's potential impact on adjacent lands to the impact from a typical automobile sales or rentals?
I don't know if that's true.
If you compared, could you describe what you compared?
Just that there was commercial activity in the residential zoning district.
No further questions.
A redirect.
Yes, thank you. So opposing counsel kept asking the question, did you consider this? Did you consider that? Does the UDO require that you consider every single one of these factors?
It says that we should consider them, that these aren't the only factors that are to be considered, but that it was not limited to these factors that we have to consider.
Also, the question kept being posed, did you compare the car sharing to the typical automotive sales and rentals? Does the UDO require that comparison?
It does not.
Okay, thank you. No further questions.
Thank you. Does the board have any questions for
Did
Ms.
you,
Turner?
just briefly, did you guys have anything in light of those questions? Did you have any follow-up in light of her questions?
No.
Okay. I just want to make sure we were done being passed
Given a
back and
fair
forth.
chance, yeah,
Yep.
right. Do any board members have any questions for Ms. Turner right now? If not, we can.
Yeah, I have a couple. So in 10.4.1 D2, with the listing of the standards for interpreting unlisted uses, the last sentence of the opening paragraph says, in making such determination, the director shall consider the purpose and intent statements in this ordinance concerning the zoning district, the character of the use types allowable in the district, and all relevant characteristics of the unlisted use, including but not limited to the following. What emphasis do you place on that term, relevant characteristics? And can you say that the county addressed the relevant characteristics listed here?
Yes, I mean, that's what we did in determining that the use was most similar to automobile rentals, was determining that that was the use, was a rental of vehicles, and that it was most similar to that use before we even heard the term car sharing or peer-to-peer vehicles.
So the listed characteristics, I want to make sure that we understand the distinction that an evaluation of each of the characteristics is required by the UDO, but not all of them have to be relevant. So as part of the evaluation of each, you can make a determination that one or more of them are not relevant to the issue at hand, correct?
That's correct, and that's what we did.
Okay.
Any other questions for Ms. Turner?
Not ready.
All right. Were there any other witnesses?
No, Mr. Chairman.
All right, you're excused, Ms. Turner.
Thank you.
And shall we go ahead and move to opposing counsel's case?
Yes, we would like to call Ms. Young to testify.
All right. Come on up, Ms. Young.
Could you please introduce yourself to the board?
Yes, I am Misty Young, and I own and live at 1086 Hampton Street in Corolla.
Ms. Young, do you understand that we are here today for the limited purpose of determining whether any car sharing you did with Turo at your home at 1086 Hampton Street back in 2022 should be considered automobile sales or rentals under the Currituck County UDO?
Yes, I understand.
And do you understand that there are 13 factors or characteristics in the county's ordinance for determining whether an unlisted use, in this case your car sharing with Turo, is similar to a listed use, automobile sales or rentals?
Yes, I understand.
I'd like to walk through those 13 characteristics with you as they relate to any car sharing you did with Turo at your home at 1086 Hampton Street back in 2022. The factors are found in the Currituck County UDO, Section 1041D2. The first is the volume and type of sales, retail, wholesale, etc. Could you please describe the volume and type of sales conducted at your home?
Yes, as a host with Turo, I shared my personal vehicles with guests. There were no sales. Turo is entirely an online platform, so all reservations were made online and all interactions with guests occurred online or over the phone. No sales or business activity ever occurred in person at my home at 1086 Hampton Street.
What about pickup or drop off of vehicles?
I did contactless pickup and drop off. Only during the off-season would guests come to my house, but more often we would meet them at their rental property.
The second characteristic is the size and type of items sold and the nature of inventory on the premises. You mentioned earlier there were no sales, so can you describe the size or types of items that were sold at your home?
That is correct. There were no items sold. I only shared my personal vehicles with guests.
Could you describe the nature of inventory at your home for the car sharing you did with Turo?
Yes, there was no inventory unless you consider my personal vehicles that I own and that are registered to me inventory. But I own and use those vehicles and park them at my home regardless of whether I also car share with Turo.
I'd like to talk to you about those personal vehicles briefly. Were the vehicles you were sharing with Turo parked at your home at 1086 Hampton Street back in 2022?
Yes, because they are my personal vehicles. I often use them to drive to the grocery store, drop my girls off at school, go to the beach. So they were parked at my home along with other vehicles I do not share on Turo. I have 2 other vehicles that I drove, and in 2022 I had 3 Jeeps that our whole family used. I would use the Jeeps to drive the kids to school, the store, or beach. My husband would drive to work, my daughters would drive to school, and our live-in nanny would use as well, depending on our schedules.
Where exactly were the vehicles you shared with Turo parked on your property?
On my driveway.
Do the vehicles have any sort of stickers, wrap, or writing on them to indicate that they are available for sharing on Turo?
No, nothing that would identify them as available with Turo, only personal bumper stickers.
Did you ever display the vehicles on your property with signs saying the vehicles were available for sharing on Turo?
No.
What about lights? Did you ever use lights to illuminate the vehicles to put them on display?
No.
Going back to those 13 factors, the third characteristic is any processing done on the premises, including assembly, manufacturing, warehousing, shipping, distribution. Did you do any kind of processing at your home for your car sharing with Turo?
No, there was never any processing, assembly, manufacturing, warehousing, shipping, or distribution. I am just a host with Turo, which only requires use of my personal vehicles.
The fourth characteristic is any dangerous, hazardous, toxic, or explosive materials used in the processing. But as you just stated, there was no processing.
That is correct. There was no processing, so no dangerous materials were used.
The fifth characteristic is the nature and location of storage and outdoor display of merchandise, whether enclosed, open, inside, or outside the principal building. Predominant types of items stored, such as business vehicles, work in process, inventory and merchandise, construction materials, scrap and junk, and raw materials, including liquids and powders. This is a long one, so let's break that down. Did you have any storage or outdoor display of merchandise for your car sharing with Turo?
No. Again, there was no merchandise because nothing was for sale, and I never displayed my personal vehicles in any manner at my home to show that they were available for sharing on Turo.
Did you store business vehicles, inventory, construction materials, or raw materials at your home for your car sharing with Turo?
No, there were no business vehicles because, again, these were my personal vehicles that I own and are registered to me. There was no inventory unless you consider my personal vehicles inventory, but again, those would be used and parked at my home whether I car share with Turo or not. There were also no other types of materials on the property because, again, car sharing only requires use of my personal vehicles.
The sixth characteristic is the type, size, and nature of buildings and structures. Did you have any buildings or structures constructed on the property for your car sharing with Turo?
No, the only building or structure on the property is my home. Turo is an online platform.
The seventh characteristic is the number and density of employees and customers per unit area of site in relation to business hours and employment shifts. Did you have any employees?
No employees. I am an individual host on Turo.
What about customers?
Only during the off-season would guests occasionally come to my house, but more often we would meet them at their rental property.
The eighth characteristic is transportation requirements, including the modal split for people and freight by volume type and characteristic of traffic generation to and from the site. Did car sharing with Turo require guests to travel to your home by car, bus, or train?
No,
Did the car sharing generate traffic to and from your home?
no,
The ninth characteristic is trip purposes and whether trip purposes can be shared by other use types on the site. Besides car sharing, what other uses, if any, were occurring at your home that would generate trips to your home?
The only other use at my home was residential.
The 10th characteristic is parking requirements, turnover and generation, ratio of the number of spaces required per unit, area, or activity. Did guests park at your home?
No, I do not allow guests to park in my home.
The 11th characteristic is the amount and nature of any nuisances generated on the premises, including but not limited to noise, smoke, odor, glare, vibration, radiation, and fumes. Did your car sharing with Turo result in any nuisances like this emitted from the personal use of your vehicles?
No, any potential noise or fumes from my vehicles would be the same whether I was driving to the grocery store or for pickup or drop off for a car sharing with Turo.
The 12th characteristic is any special public utility requirements for serving the proposed use, including but not limited to water supply, wastewater output, pretreatment of waste and emissions required or recommended, and any significant power structures and communications towers or facilities. Were any special public utilities required for your car sharing with Turo?
No, the only utilities on the property are for my home and my personal use.
The 13th characteristic is the impact on adjacent lands created by the proposed use type, which should not be greater than that of other use types allowed in the zoning district. Could you please describe the difference in impact on adjacent property, if any, between driving your vehicles for your own personal use and driving your vehicles for car sharing with Turo?
How I drove and parked my vehicles was the same, whether I was driving to the grocery store or for a drop-off or pickup for car sharing with Turo. There was no difference, and so there was no difference in the impact on adjacent property between my personal use allowed by my residential use of my home or my car sharing with Turo.
Thank you. No further questions at this time.
All right. County cross-examination.
Yes, thank you. You mentioned earlier that there were no trips to and from your property when looking at the transportation requirements. Is that right?
I do not recall saying there were no trips.
You testified that there were no cars going to and from the property when she asked about trains, buses, cars.
That is correct. It does not require that.
But you also testified that people do drop off and pick up at your home.
I said occasionally, but more often we bring them to them, but people often walk. Corolla is a small community.
You also mentioned that how you drive makes no impact on the adjacent landowners, but what about the people who are dropping off and picking up?
No difference than my own personal use.
Okay. No further questions.
Redirect.
No redirect.
Any questions from the board for Ms. Young?
I have one, and Ms. Young, maybe if you can't answer this, maybe your counsel can, but Can you, can you tell me what the definition is of a typical automobile rental establishment would be? Because I've heard that term used a lot tonight, and using that and comparing what you're doing to the standards in the UDO, it makes it difficult for us to make that comparison if we don't even know what that definition is. Do you have a definition of what that means?
Do I have a definition of car rental and sales?
Yes.
Yes.
No, I mean, do you have a definition of a typical automobile rental establishment?
If it is okay, we can answer that because we do have. That was what we were trying to get Ms. Turner to testify to earlier. The UDO does provide a definition.
No, I'm not talking about the UDO definition. I'm talking about the term typical automobile rental establishment. What does that mean? Typical.
So it would be looking at the definition in the UDO and saying what the typical would be.
No, that's not, that does not mean typical. Typical means you have some numbers, values, documentation on what typical means. Now, we know what it says in the UDO, but what does typical automobile rental
Well,
mean?
I would say it's not me, because what I'm doing is ride sharing, and that's not defined in the UDO.
But that definition is being used by your attorney to
Ride
compare
sharing.
what you're doing.
Ride sharing or car rentals?
Typical automobile rental establishment.
We
What
would
does
say-
that mean?
An example would be a Hertz or an
That,
Enterprise.
that's not an example. Typical. Typical means you have a definition of what that constitutes.
I would say a large volume of cars being rented commercially.
And where's that definition found? Large volume.
I would say that that's what the average person would say is a car rental business.
Who is the average person?
You.
No, I would not say that, because I cannot define what a typical automobile rental could be anything.
Okay, me. Since you're asking me the question, I would call a car rental business a commercial place with multiple large volume vehicles being rented or sold.
And you have a definition of that to back that up?
Didn't you guys refer to Webster's dictionary for the term that you guys used before?
Rental? Mm-hmm. The term rental? Mm-hmm. I don't recall if we used that term, but a rental is a rental.
What is ride sharing?
I'm just trying to understand what a typical automobile rental operation is. What's typical? How do you define that?
Typical would be commercially owned vehicles on a publicly viewable lot being rented and sold at a high volume, and people being able to come in person to an office at a business location, place, make payment for that vehicle, inspect that vehicle, and then provide insurance or whatever other requirements provided by that rental company. And again, volume is a very key word here. Volume is many vehicles, when I had 3 personal vehicles that were not commercial vehicles.
And if we may, the reason why we asked Ms. Turner that specific question about what the typical would be and trying to get a definition is because we would argue it is the county's burden to establish what a typical use would be, so we understand what we're comparing Ms. Young's activity to.
There's no such thing as a typical auto rental business, right? It's an activity-based definition. It's an action. There's no typical. And that's what I'm trying to get out of you, because you use that term a lot. And I'm trying to understand what you mean by that so that I can compare it to what they've done in their analysis.
I think we would simply disagree that when you're looking at different types of land uses, there are very common or typical types of uses that would fall under those different categories. And in this case, an example of that, again, would be like a Hertz or an Enterprise.
But there's nothing in the definition or any legal definition that specifies a qualifier for volume.
No, again, that would be one of the characteristics of the 13 characteristics to look at does include the volume. And again, that was on the county
Right.
to look
Well,
at.
I'm saying it's on you because you use the term typical. So I'm trying to understand what you mean by that. I need to understand what that means so I can make my determination here.
Well, the state of North Carolina does define ride sharing. And
I'm not talking about ride sharing. I'm talking about typical automobile rental business.
but we're not an automobile rental business.
But I need to know what she meant by using the term.
But we don't need to provide that.
That is what we meant. And,
So
and
I
we
don't
would-
want to, let me just, time out. Let's just pause for just a second. This is, because this is a remand and we are trying to narrow where we are, we cannot, there's multiple things here. In my instruction to the board, and I believe to council, has been, Judge Tillett remanded for the board to either issue another order based on just the record as it was, have a whole new hearing, or have an additional hearing on specific factors by which they're going, for additional evidence. Okay, now, to be clear, that's additional evidence on those factors. And so I think that, part of this is, we already have a record established on multiple things, which neither party, and I mean, either side has not gone back to rebuild because that's already in the record for the board's consideration. But in terms of typical definition of ride sharing, I know she wanted, that's already in the record from the prior time. So this issue of typical, I guess just, if there's any, I think she said she doesn't have a definition for typical. I think Ms. Farmer said she was using that because their contention is that that was for the county to prove typical. So in light of that, is there any other?
No, I was just wanting to try to get an establishment of what they meant by that term because that term has not been used in here before tonight, to my knowledge. And so the term was being used as if it's defined somewhere. So I wanted to know where that definition is so that I can use that in my determination of whether these standards have been met or not.
Okay. And Ms. Farmer, to be clear, the definition that you were referring to about the car sale and rental, can you give us the citation? I know you have it right on hand. I don't have it right on hand.
Yeah, it is section 10.5 that defines automobile sales or rentals.
Okay. Thank you.
Any other questions for Ms. Young?
No, none here.
I have one question for you, Ms. Young. Thank you for coming tonight. My question to you is, your council has mentioned a couple of different big rental companies like Enterprise and Hertz and whatever. Am I correct in saying that don't those even big companies have an online presence where a person can rent a vehicle over the internet without visiting a location other than to pick up a vehicle?
Yes.
Say that's a yes or a no
Yes,
answer.
I would say that most large volume car rental companies have an online presence, but everybody has an online presence today. So I'm not sure how that's relevant.
Thank you very much. There's no other questions? Okay, you're excused, Ms. Young. Were there any other witnesses on either side?
None for the county.
Would y'all like to go ahead and have
Okay.
your closing arguments?
Yes, Mr. Chairman, that would be great. What order, would you like for the county to go first?
The county's fine. Yeah, being
Okay.
as you all started.
So again, the reason that we're here tonight is for the very limited purpose of getting findings that relate to those 13 factors in 10.4D2. Ms. Turner got up on the stand and she did just that. She went through each characteristic that the county found relevant. The county is not required to consider every single factor, but consider only those that they find relevant. She went through each one of those and she described how, what the characteristic of the use that Ms. Young is doing, as well as the characteristics of automotive sales and rentals. That is the only reason why we are here. And the Ms. Young's attorney consistently asked Ms. Turner whether that characteristic, that they looked at that characteristic and they looked at the car sharing and then compared it to the typical automotive sales and rentals. The UDO does not require that. So I really don't understand why any of those questions were asked. There's no requirement. I will read off to you what is actually required in the UDO. In 10.4.1D2, the director shall interpret an unlisted land use as permitted in a particular zoning district only after determining that the nature, function, and duration of the use and the impact of allowing it in the zoning district are so similar to those of a use type or use category allowable in the zoning district that the unlisted land use should be deemed allowable in the same manner as the similar use type or use category. In making such determination, this is key, the director shall consider the purpose and intent statements in this ordinance concerning the zoning district, the character of use types allowable in the district, and all relevant characteristics of the unlisted use. And then they list out those factors. Nowhere does it state any kind of comparison of a typical automotive sales and rentals. So I believe the county has fully met their burden in going through every one of the factors that they find relevant. So the county requests that you adopt the findings that Ms. Turner testified to earlier, and again, affirm that notice of violation. Thanks.
All right, thank you.
As was stated, Judge Tillett remanded this case for the limited purpose of allowing the county to present clear and substantial evidence to the board so that the board can provide findings regarding its consideration and application of the 13 factors in UDO Section 1041D2 for determining whether the unlisted use of car sharing is similar to the prohibited use of automobile sales or rentals in the SFO zoning district. In that section, as was read by Ms. Turner, the director shall interpret an unlisted use as permitted in a particular zoning district only after determining that the nature, function, duration of the use, and the impact of allowing it in the zoning district are so similar to those of a use type or use category allowable in the zoning district that the unlisted use should be deemed allowable in the same manner as the similar use type or use category. That is why we ask questions, and that's why it is important for the county to establish what does a typical automobile sales and rentals look like, so we can understand whether the unlisted use should be deemed allowable in the same manner as the similar use. That is exactly what the UDO calls for, and that is why it is relevant. The county has failed to present sufficient evidence that would allow this board to make those necessary findings, and as such, we respectfully request that the board reverse the notice of violation and interpretation that the unlisted use of car sharing is similar to automobile sales and rentals and is therefore prohibited. In considering this appeal, the board is limited to the 4 determinations in UDO Section 2417D, Appeal Review Standards. The board must find that the county, 1, did not make an error or correctly applied the standards of the UDO in making its decision or interpretation, 2, made an error in determining whether a standard was met, 3, made the decision based on a standard not contained in the UDO, or 4, made an error in applying a standard or measuring a standard. Based on the testimony and evidence that was presented this evening, it is clear that the county made its decision based on a standard not contained in the UDO and in violation of North Carolina law. Peer-to-peer vehicle sharing or car sharing, as you heard this evening, is not defined in the use table or elsewhere in the UDO. Chapters 2 and 10 of the UDO, as Ms. Turner stated, set out the procedure for interpretation of unlisted uses, and there are only two options. 1, the unlisted use is similar to a listed residential use and is therefore permitted, or 2, the unlisted use is not similar to a listed residential use and is therefore prohibited. What the county did here does not fall into either of those options. Instead, the county determined that the unlisted use was similar to a non-residential use not permitted in the SFO district and was therefore prohibited. That is not an option in the UDO, and the county had no authority for making that determination. If you look at section 1041D2, which contains the 13 characteristics that are the subject of this remanded hearing, as we established with Ms. Turner, it is entitled Standards for Interpreting Unlisted Uses as Permitted. Nowhere in this section does it say there is authority to prohibit a use based on finding a similarity using the 13 characteristics. As we established with Ms. Turner, it is the next section, 1041D3, Unlisted Uses Not Permitted, that governs the analysis for prohibiting an unlisted use. This section says that if, after applying the 13 characteristics, an unlisted use is not similar to a listed use, then the unlisted use must be prohibited. Nowhere in this section does it say there is authority for what the county did, which was to apply the 13 characteristics and determine the unlisted use is similar to a listed use and therefore prohibited. In making this determination, the county only analyzed 5 out of the 13 of the characteristics, and the only similarities that appeared to be identified this evening was that Ms. Young had cars parked in her driveway. But having cars parked in your driveway does not equal rentals or automobile sales or rentals. If the issue is simply how many vehicles are parked in the driveway, that is an issue for Ms. Young's HOA, not the county planning department. The reason that the UDO does not contain an option for what the county did here is because it would directly violate well-established North Carolina law. The North Carolina Supreme Court decided this exact issue and set clear precedent for interpretation of unlisted uses. In Byrd v. Franklin County, the Supreme Court held that a county land use ordinance that failed to expressly allow an activity could not be construed to implicitly prohibit that activity. This is because of the long-standing common law principles of the free use of property. The exercise we have done tonight in taking the 13 characteristics in 1041D2 and determining whether car sharing is similar enough to automobile sales or rentals such that it would be prohibited was also specifically contemplated by the North Carolina Court of Appeals in Land v. Village of Wesley Chapel, and the court found this exact approach unfavorable. The court found that if a citizen seeking to use land for otherwise legal purposes would have to speculate as to which use was similar to a category in the county's ordinance in order to know what was permitted or prohibited, it would leave the landowner exposed to the whims of zoning authorities who may disagree with the landowner's interpretation concerning similarity of use. The court held that, quote, unless an ordinance clearly prohibits a particular land use, that land use is allowed. The law favors uninhibited free use of private property over governmental restrictions. If the county is allowed to take an unlisted use and simply compare it to a listed use and prohibit it, the county is failing to clearly place the public on notice as to how that use is regulated, and it is an unlawful interpretation. For these reasons, we respectfully request that the board reverse the notice of violation. Thank you.
And so to be clear for the board, and I appreciate both council's argument that if you would refer to Judge Tillett's prior order, his order on remand is that it is remanded to the Board of Adjustment for the limited purpose of providing findings regarding its consideration application of factors provided in the UDO for determining whether petitioner's unlisted use was similar or dissimilar to a prohibited use in such zone. The order does not require a new hearing before the BOA. The decision of whether to hold a hearing regarding those factors rely on the record evidence and/or, so this is an and/or, you have an option to do a mixture of these things, is left to the BOA in consideration with the parties or stipulations between them. And so to be clear, while I appreciate both councils' argument asking you to affirm or reverse your prior decision, we are not here tonight on a new hearing. This was not remanded for a new hearing. This was remanded for providing specific findings. I think they were both very clear on whether the findings were met or not met in their position, but for your consideration moving forward, you are here for additional findings, to make additional findings. So based on what you have here tonight and/or the record of the prior hearing, the exhibits of the prior hearing, your prior order, arguments of counsel, which has been here. So you have all of these things that have been sworn under oath presented for your consideration. So you're not here deciding whether you're going to affirm or dismiss or the notice of violation. That's not why you're here tonight. So that was included in your January 11th, 2024 packet, and I'm not sure if it didn't make it in this agenda packet, Judge Tillett's order? Okay. I think everybody has it, though, so I don't want to be speaking out of turn, make sure we're looking at the same thing. So I'm looking at the one that he issued September 29th of 2023.
And if I may, I do want to speak to your point because we respectfully disagree with that. We think that in order to comply with Judge Tillett's order and sufficiently consider the 13 factors, the board then necessarily has to decide whether it would reverse or affirm the notice of violation. Because Judge Tillett's order stated that the Board of Adjustment failed to provide sufficient findings regarding the consideration of those 13 factors, and that he could not determine whether evidence was competent material or substantial evidence. So the record going forward has to show this board's consideration of those factors, which there was no evidence on the first time around.
Well, your contention is there was no evidence on that the first time
The record still
around.
has to show this board's consideration of those 13 factors. And then, based on its consideration of those 13 factors in connection with the remainder of the record, determine whether to affirm or reverse the notice of violation. Because the evidence presented tonight may sway the board to make a different determination. And I think that's what Judge Tillett's order contemplated. Otherwise,
But that's not what it says.
No, that's exactly what it says.
So are you looking at page 5 of his order that says this matter to be remanded for the limited purpose of providing findings regarding its consideration and application of factors? So he asked the board to send him another order regarding their consideration, and that the board didn't even have to hold this hearing. The board could just rely on the prior record. And the fact that the board didn't rely on the prior record is there's been no indication or motion by the board or anything that indicates the board did not feel like the record would not be sufficient, other than providing another opportunity for both parties to be heard on the factors.
Well, I mean, I don't know what the purpose of tonight's exercise is, then if it doesn't result in a determination by the board that either party can then appeal to Judge Tillett. The board has to indicate what its review of those 13 factors yields, because it may be a different result. I mean, otherwise, what's the point of conducting the hearing pursuant to Judge Tillett's order?
To provide any other findings, specific findings regarding those factors,
Right,
one
but
way
if
or the other.
If this board considers those factors and then does not make a determination, then there is no determination made based on the entire record. And that's the problem.
No determination is a determination.
So your contention is that the board has to either affirm their prior decision with additional findings or reverse their decision based on something they heard tonight that changes their mind,
Correct.
such that either party can then appeal the remand.
That's correct. Because otherwise, on appeal, Judge Tillett or whoever the Superior Court judge is hearing it would have no way to tell what impact the consideration of the 13 factors had on the board's ruling.
Well, and I guess that's my issue is that the Judge Tillett's order says that the board could just submit a new order, right? I mean, does not have to have a new hearing. That's what this order does not require a new hearing before the Board of Adjustments, which means you can issue a new order from which the parties can appeal.
Right.
So tell me how that contemplates what you're saying, is that they have to make some new decision.
So this board could have gone back to the record that was established in 2022 and rewritten its order
Sure.
to give express consideration of those factors, but it chose not to do that.
Well, no, Judge Tillett's order says and/or.
Right.
And/or, which
Right.
means the board can do multiple things and issue a new order based on the prior record, arguments of counsel, and this hearing from which everybody can appeal.
But the board in the March session voted to conduct this hearing, which would then necessarily lead to the entry of the new order.
Judge Tillett's order says this order does not require a new hearing before the board. The decision of whether to hold a hearing regarding those factors rely on the record and/or arguments is left to the board in consideration with the parties or stipulations between them. His item 2 on that page 5, the very last thing in his decretal portion of the order, which is the controlling portion of the order, says the board does not have to have a hearing. Just because, and it says and/or, which means the board has the option to do multiple things, so there's going to be a new order. But it does not require a new hearing or a new decision. It simply means the board can accept new evidence to issue an order.
Right, but what if it's the board's determination that its acceptance of new evidence results in a different ruling? I think the board has to make that determination of either it does or it doesn't, because the board can't enter an order saying, we considered all of these factors, and then not say what the result of the consideration of those factors was.
Well, I mean, that's what Judge Tillett's section number 2, item number 2 says. How could they just go back and reissue a new order? They said we're going to have a limited hearing for consideration and application of providing findings, for the limited purpose of providing findings regarding its consideration and application of factors. So now the board has, and then number 2 says the board can hold a hearing, rely on the record or evidence or arguments of counsel, and it's in the board's discretion in consideration with the parties. And so the board said, we're going to ultimately allow all of those things such that both parties have the opportunity to provide as much or additional information as possible for the board to then reissue their order. So this has not been sent back down to the board for a reconsideration. Now, I agree, the board's findings based on additional factors or tonight's hearing could sway them or decide that one of the factors finding may have been not applicable. We heard that tonight, right? We didn't apply that factor. So I think Judge Tillett's order is clear that the Board of Adjustments order has to delineate what things they considered in regards to the factors, right? But that doesn't mean they're limited to only this hearing tonight.
But I think they are, but because under your interpretation, it's possible for this board to conclude that there is no similarity between automobile sales and rentals and the use that was happening at 1086 Hampton Street, but would nevertheless be bound to conclude that the NOV has to be affirmed.
No, I'm not saying that. I said they could find that one of the factors, they could say that, we'll use the hazardous materials, because I think that everyone agrees that I don't think there was toxic hazardous materials based on car rental or car sharing, whichever side you're on. And so the board could make a finding that says dangerous, hazardous, toxic, or explosive materials used in processing. This does not apply. So that would be a factor to the negative, right? Mm-hmm. Okay, so the board could find that. That's not going to, that's my point, is they could go through and make certain findings about certain factors that it doesn't necessarily comport to or agree with or the county, but it doesn't mean they're going to overturn their decision.
I agree that it may not result in the decision being overturned, but that's the board's decision to make. And in fact, I'll point out that that's what both of the parties are asking for, is not only for a ruling and consideration on those 13 factors, but then the next step of affirming or reversing the NOV. That's at least what I heard in the county's closing argument.
Yeah, I think, in my opinion, I definitely agree with what Ms. Wamble is saying. Judge Tillett's order is a unique one in that it's just asking for the factors for us to just go through those factors. But I think for a complete order, you would have to say what your final decision is, whether it's the same or if it's different. I mean, I think just to complete out that order is what just makes the most sense.
Well, I guess you guys can, one, decide based on, and to be clear, the board's position is that this, well, that this hearing, that they were looking at item 2 and that this hearing and the record and the evidence, just like we noted before, Ms. Young noted the definition of car sharing. I said that's in the record for consideration. And so I guess first you should make a motion about whether you're going, if there's anything that you heard tonight that is going to change your opinion as to whether you're going to affirm or reverse your decision based on what you heard tonight. I guess in conjunction with what you heard previously, because if you're going to make a decision to affirm based on what you heard tonight and what you heard previously, so, and the record. So you, I guess, address that first, and then we need to address the 13 factors based on that decision, if you're prepared to do that tonight.
So based on the judge's order, if we were to address the factors for the record, to supplement the record and not make any other decision affirming or, denying the previous decision, is the decision by default the same as the original? And we're just supplementing the record with this additional information? How does that work?
I guess that's what I was saying, but both parties are asking you to take a vote on whether you are, and I guess this is where this Judge Tillett's order is challenging to us, because he gave you the option to have a limited hearing on factors. But blended with arguments of counsel and also the record as it exists. And this board opted to have a limited hearing in addition to those other things. So in regards to whether if you're going to make a decision whether to affirm or reverse the decision, you're looking at the entire record. And are you prepared to do that tonight? Because you had the prior, I don't know that the prior packet was included, although you guys have seen it and had it in preparation for this scheduling. So I'm not trying to prompt you not to be ready. I'm just asking, that you have this record. And if you're prepared to render that decision, then you can do so. In regards to the findings, if you're ready to go through all those findings tonight and make findings based on that, the order has to be drafted. I think given the appeal process either way, this is one of those orders that I would bring back to the board for a review and for you guys to specifically approve, to ensure that the findings were as you want them, as you expect them. You guys don't dictate word for word your orders. I don't know any board that does. But you do have to have deliberation about the factors and things that, are relevant to you. And I think that you need to be able to point to those in the record as well. So it's just why I would bring the order back to you, one way or the other.
Okay, so if I'm understanding this, then Judge Tillett sent this back to us because he didn't think that we had taken into account the 13 points?
Well, his order says that he can't tell from your order specifically the different things that you considered or what evidence that you considered in relation to those factors.
Okay.
So, he gave the Board of Adjustment the discretion to review the record, use the record and the exhibits and the testimony from the prior hearing, in addition to arguments of counsel, in addition to a limited hearing on the factors. And so now you've had all three of those.
So on the factors, does the county have prepared, or do you plan to prepare a written report, assessment of the factors, of how you applied the factors?
We can.
I think that would be important for the record. We can go through and talk about the factors.
So I think if you're going to give the county the opportunity to submit a report about the factors and the application of that, you need to give Ms. Young's counsel the opportunity to submit. I mean, that's kind of like a written argument ultimately. I mean, at this point, I mean, do you agree?
I agree, and I think Ms. Turner testified to the factors that she considered. While I do think it would be helpful to the board to have that staff report, and we could have provided that. It is in the record.
Yeah, I'm just wanting to make sure that we have something in the record, because I know we heard the testimony. We all heard it here today. But, I just wanted to make sure that we're able to translate what we heard to the factors that we considered, and I don't know if we would need a report to be able to, build that in the record, or is this meeting itself the record?
The meeting is so this is being recorded, and we certainly can get a transcript if we need to, or, I mean, I know that it would be painful, but you could rewatch it. But I would argue that the testimony is part of the record.
Yeah, so, I mean, again, you got to remember competent evidence and what is considered, and that's one of the things Judge Tillett mentioned in his order, which is why I started out earlier, like, let's be clear what's in the record, what's being sworn testimony. And so if you're asking for additional information that you feel like you don't have, you need to give that opportunity to both parties. If you're asking for them to submit argument, which does happen in court, attorneys will submit written argument about the evidence that was presented, and they kind of will basically write out what they argued tonight in probably greater detail, because if I was given the opportunity, I'd go back and write it out, which I've done before. So you could ask for that, but we just need to be sure, like, I guess we need we need to make sure we're identifying what it is you're asking for, if it's going to be evidence or if it's going to be arguments. Judge Tillett's order says that it can be and or arguments. It can be, the board can decision on whether to hold a hearing regarding these factors, rely on the record, evidence, and or arguments. So you could ask for further arguments, although they already argued. So if there's information you need in order to do this,
I don't think
through-
there's anything additional. I was just curious if, if we're being asked by the judge to evaluate these standards and show that we evaluated the standards, do we need something like, a report from the county, or can we just use the meeting and the transcript, the meeting itself, as the evidence
Right.
that we considered the standards?
Well, and I guess that was my question to the board here, which is you don't have the whole packet wasn't in the whole prior record wasn't in your agenda packet tonight. And because you are the four here to make this decision and, I guess, reissue an order, are you prepared to do that? Do you need to recess and such that you can consider what was said tonight, like go back and watch the video, and or I don't know that we can get it transcribed quickly, but transcribe quickly so that you can review that in addition to the prior transcript, which you have, and the record, in order to render a decision, particularly since they're asking for you to affirm, reverse, and then you've got to discuss what you've considered. And because I've got to be able to draft an order
Right.
for you. And then you guys are going to have to review that. So I guess that was my question to the board is, do you feel like you're in a position to analyze all that tonight?
I think we're in a position to talk about what was discussed with the standards. I mean, if that's what we're here for, we heard the testimony from both sides on the standards, and there's the discussion of whether all the standards have to apply in order to make a determination, or if some of them have to apply, others don't, or not relevant, but you still have to look at them and make a determination that they're not relevant and why they're not relevant, that sort of thing. What do y'all think?
My opinion is that we do not need to delay by having additional things to review again. The case was already made previously with all the evidence. We have a transcript of verbatim of everything that was said during the last hearing. We've had witnesses here tonight that have given testimony, and we've heard all of that. They went over every one of those 13 points. I don't believe we need to delay it. I'm ready to talk about how we are interpreting the 13.
Yeah, I agree. I think that, we, as long as the transcript has that we addressed, analyzed, looked at those 13 points, I think that we don't need to delay any longer either.
Well, and I think it would be helpful for you and for me is if you would look at your prior order and note where, what information is you considered relevant. That's why I'm asking you about the prior record is, unless you just want me to take your prior order and apply it to anything in addition to what you say tonight, I need some guidance about the scope. If you're relying completely on the entire prior record, your prior order, in addition to the things you say tonight, I need a scope of what if we're encompassing everything or where you are.
Doesn't it seem logical to include everything that's happened all the way up till today and including today as far as what we've heard in evidence and what's already been submitted? That seems logical to me.
Yeah,
Instead of redesigning the initial order, the augmented order that will come after whatever decision's made tonight,
And
to include what we agree or disagree upon the 13 standards.
Well, first, I think you need to decide if you're going to affirm or reverse the board's initial decision based on council's request, and then based
I
on
don't think we
that.
can do that until because I think our discussion about these standards will help us determine whether we are going to affirm or overturn the previous decision, correct? Right? If there were something,
Obviously, that would occur after we've discussed
Right.
all of these.
right,
Got it.
Right.
right, because I think the idea is, what the judge said was that he could not tell from the record that we had evaluated these standards and applied them. So I guess that's what we're doing now.
In my own opinion, based on the comments that the attorneys have mentioned, it seems logical to make a decision about whether to augment, change, leave it as it is. It just makes sense to make a determination about our previous decision.
Okay.
Including all of the prior data that we had already received, all the testimony, and including tonight's materials that we've witnessed here. That makes sense?
Yep.
So
Makes sense to you
isn't
all.
our job here to decide whether the county made an error?
Yes.
Was
so
what the
when
original
you're-
one was, wasn't it?
When you are reviewing an interpretation, you are, let me read you the section. And I'm looking at 2.417.8. Is everybody with me?
Say the numbers again for me.
An appeal, I'm looking at the appeal provisions.
2.4.17.
C8, yes, I skipped over the C. I'm sorry, yes, C8.
Repeat that one more time for us.
2.417, C, I skipped over the C, 8.
A is
And
in Adam.
A is 8.
Or 8.
8, the number 8.
Okay.
And then it says, A, the Board of Adjustment following a quasi-judicial public hearing, and then it gives you the 3 options. Affirmation of the decision or interpretation, this is in whole or in part. 2, modification of the decision or interpretation, in whole or in part. Or 3, reversal of the decision or interpretation, in whole or in part. So when you are reviewing an appeal of a staff determination, those are your 3 options.
I have a question procedurally. Being that our agenda states that this is a public hearing, shall I open the hearing, public hearing, and then immediately close it to say we actually did have a public hearing, even though there are no other members of the public here to
So
speak?
it says public hearing, which is kind of a misnomer. So quasi-judicial public hearing is a quasi-judicial hearing is a hearing where there's sworn testimony, competent evidence. This would not be a public hearing. So a public hearing is open to the public to give comment. So Currituck's the Board of Adjustment rules of procedure are a little funky that at the initial quasi-judicial proceeding, the board, after all of the testimony by either party, the board opens the floor for other people to give comment, although that comment's not, part of.
By experts.
Right, okay, and so, but for tonight's
Yes.
hearing, it's a hearing based on sworn testimony, based on this remand. There is no public hearing to call and open and close
Thank you.
unless either attorney has an objection or comment otherwise.
No, I completely agree.
Okay.
Just want to make sure that that got included if it were needed or
I don't
not.
think it's needed. Do you have an objection to the way we've proceeded?
No objection. No, I guess for the record, there's nobody here anyway.
Yes.
There's no public.
But no, so
And sometimes that happens at a regular first public hearing.
it does.
So there's
It
no one
does.
there, and you open it and you immediately close it.
Yes, but this is different.
Thank you.
In fact, all quasi-judicial ones are different, but anyway.
Are you
Alright.
all ready to
Yeah.
proceed?
Yeah.
Or do you have any questions procedurally
No, I think,
for our
I think,
council?
I think I'm
No,
good. Yeah.
Shay,
Nope.
anything for you?
No, I'm good.
Is there anything else procedural? I mean, I know I was arguing with you, but I just want to make sure I want to make sure when this goes back up that we have covered everything, we have done everything. I'm trying to be thorough in this order and make sure we're not doing too much or not enough. If everybody wants that decision to be made, I think both councils asked for that. That's fine. Is there anything else before they kind of proceed into deliberations? I just want to make sure we're covered.
No, not from the county.
No, nothing further from us.
Okay.
All right. Is there any discussion before we begin going through the 13?
No, I will say that the way the UDO lays out unlisted uses is a little bit confusing. You know, the standards for interpreting unlisted uses as permitted, which are the standards we're looking at, and I guess in the other section in 3, you know, it seems to be making a comparison between an unlisted use and a listed use that's approved. The listed use is approved in the zone that it's in, right? But what we're talking about here doesn't really apply there, because we're talking about an unlisted use that we're comparing to a listed use that is not allowable in that zone. So it makes it can kind of trip you up when you're reading through this. Even in the section D3, unlisted use not permitted. It's telling you, after applying the criteria, the director determines that a proposed unlisted use is not similar to a listed use. The proposed use shall be prohibited. So if we make the determination that the unlisted use is not similar to the listed use, it's telling us that it shall be prohibited. So it's kind of quirky there, but getting into the standards, I think I mentioned earlier on, we talked about the first paragraph in D2, the last sentence of the first paragraph that says that the director shall consider the purpose and intent statements in this ordinance concerning the zoning district, the character of the use types allowable in the district, and all relevant characteristics of the unlisted use, including but not limited to the following. So one thing I think we should talk about is that term relevant, and how it's worded here in the UDO. Does that term relevant apply to the 13 standards? Meaning, you know, those that really don't apply to a particular situation or condition, you know, we review them, but we have to make a determination that they don't apply.
And also nowhere in D2 does it state that one must occur or all must occur.
Right.
Not specific as to how many of these will cause one to be similar or dissimilar.
Right, right. And that sort of gets to what I was getting at earlier, you know, when we were talking about the definition of a typical automobile rental enterprise, right? And what does that mean? You know, there's really not a definition of that. So making that comparison here, you know, as that applies to these 13 standards is a really difficult task, right? You really can't do it because you don't have a definition of what the one side is, right? But I will also say that when you're making a comparison between different uses, different things, sometimes you don't have to compare standards that are not relevant to make a comparison if they are similar on its face.
And that would be the line, but not limited to,
But not limited to. Exactly.
in D2.
And there's some other language in here, and you know, it's not maybe necessarily directly related to the standards, but it is related to the purpose and intent within the UDO and how it defines these use categories, right? So if you go to the beginning of section 10.4, 10.1, it talks about principal characteristics, principal use characteristics. And it says in 10.4.1 B2, principal use characteristics, the characteristic subsection describes common characteristics of each use category. Principal uses are assigned to the use category that most closely describes the nature of the principal use. And then it goes on, and what this is doing is it's describing how the use category definitions are laid out later on in the UDO, right? So there's a principal use category that it lays out, and then it goes on to talk about examples. So each use category is defined in the UDO by the use category, and then it includes examples. So what it says in 10.4.1 B3, it talks about what they mean by the examples that they use for each of the use categories. So it says the examples subsection lists common examples of use types included in the respective use category. The names of these sample uses are generic. They are based on common meanings and not on what a specific use may call itself, right? So keep that in mind. And then if you go over to the vehicle sales and services use category, it defines the characteristics, and then it's got an examples paragraph. And it says example use types include automotive sales or rentals, including the sales and rental of automobiles, motorcycles, and light trucks. So it doesn't talk about volume. It doesn't talk about how they're staged. It doesn't talk about any of these things. It just talks about
Or how large or small.
or how large or how small. It just talks about rentals.
And
Right.
that's what I'm sort of looking at is, we listened to both arguments on all these 13s, but you also mentioned relevant. I'm not sure that any of them are relevant to our actual decision.
Well, there's an argument. I mean, there are a lot of them don't appear to be relevant in this case because the activities are so similar on their face that it's folly really to go through and try to make these standards apply when they actually really don't, because on its face the operative word is rental, right?
Exactly.
So what is a rental? Like, what are we calling a rental? It doesn't, nothing in the UDO factors in volume, size, frequency, staging, lighting, signs, none of that. It just says rental. And so for us as a board, we have to make a determination based on what the county is saying that this activity most resembles an existing use in the land use, in the UDO. So I think when we talk about these factors, and I know the county has talked about which factors they applied and which ones they didn't, or which ones were not relevant. Not that they didn't apply, they were not relevant. I think that's an important exercise for us to walk through these and talk. Are they relevant? And on the face of it, when it gets down to it, the definition talks about rentals.
And that's why I said that I didn't find any of the 13 particularly relevant to our initial decision. That's my thought on it.
I don't agree with that statement you made, Robin, but
Okay?
I believe that many of those were under consideration at the time we made our initial assessment and our decision. Although we did not call them out individually or specifically,
Like I said,
items within that list
I agree with that. Yes, absolutely.
And your
were a
order
part of the
did say
decision.
that, your prior order that you issued noted that, and Judge Tillett actually referenced that in his order. It says that the hang on, I was looking at the wrong one. I was looking for the citation. It said that the Board of Adjustment concluded that staff properly applied the standards in the ordinance, and it listed 10.41, and I can't put my finger on it, but there's a specific paragraph where Judge Tillett said, the board concluded this, but he can't tell by, give me a second. The Board of Adjustment found pursuant to UDO 10.4.1, I'm looking at page 3 of Judge Tillett's order for council if you're following along. D2, county staff properly determined petitioners to be most similar to automatic sales and rentals, which is not prohibited for properties designated for residential use. The board also found that the petitioner did not have a special use permit and that the standards in the UDO for that use require a special use permit. And so, then he went on to say, in his conclusions of law on page 4, the board failed to provide sufficient findings regarding the director's consideration of 13 factors to determine the nature, function, and duration of car sharing use was similar to automotive sales and rentals. So your initial order did determine and found that staff complied with that section of the ordinance, properly applied it to determine that use, that car sharing is car rental, and that the way that car rental is permitted in the ordinance through a special use permit was not applicable here because it's not permitted in residential. That's what you found before, and Judge Tillett said you didn't provide findings. Excuse me, the board failed to provide sufficient findings regarding the director's consideration about the nature, function, duration, which is where those standards apply, et cetera. I mean, I shortcut through the paragraphs, but that's.
Right.
Yeah, we didn't specifically name any or all of the 13, although we considered them in our last decision.
Yeah.
So do you believe it is logical for us to go through the 13, talk about them, and then have a specific motion for the entire 13? Or how would you prefer to do that?
I don't think that you have to have a specific motion for the entire 13. I think you need to discuss that and then I guess make your decision about whether you're going to
One of the three.
one of the three, and then ultimately you're gonna have to I mean, if there's a disagreement, you're gonna have to vote on, if some of you say this one applies and some say that this doesn't apply, I think you're gonna have to kind of go through so I know what findings to make or not make,
Right.
to propose in the order to you, but. But I do think you need to go one by one
Right. Discuss each.
and discuss each one.
Are you all ready to move
Yep.
ahead?
Yep.
Are you, Robin?
Sure.
All right, let's take 10.4.1D2A. And we're just going to go down the list A through M. And we'll just talk about each one, what your
Okay.
opinions are about that.
Okay.
Does that sound logical?
That sounds
All right.
good to me.
Okay. A, the volume and type of sales, retail, wholesale, et cetera. Tell me what your opinions are about that.
I think it's relevant, but only partially so. And the reason being, I don't think the volume of sales is relevant here because the definition that we're applying in the UDO
I
doesn't.
want to be clear, sales, rentals, are you?
Yes,
I mean, I
sales,
just wanna-
rentals, yes, sales, yeah, it doesn't really say, I presume it would mean rentals as well.
I just
Retail
want to make
is
sure
as
we all
retail, right?
understand
Yeah,
what you, I think I know what you meant
Yeah.
by that, but I want
Yeah,
to make sure
yeah.
on the record that
Right.
when you say sales, do you mean sales, or specifically in this case, rentals, or are you
Right.
saying?
Yeah. Sales meaning income from a rental.
yeah, I'm looking at it, strictly from comparing this unlisted use to the listed use that's defined in the UDO. Which again, the listed use makes no mention of volume. It only talks about sales and rentals,
And
right?
How do we know what that is, what the volume is?
Well,
How
that's,
can we-
well, that's why I was asking the question.
Volume may not be relevant.
Yeah, that's why I was asking the question to the applicant's counsel and what they meant by typical, because I'm trying to understand, to make a volume determination, right? If volume is important, I need to know what that means, from a typical, if there's not a definition for a typical automobile rental business, right? There's just not a definition of it, so we can't really apply volume. So it only falls back to the operative word, which is rental.
So, and I just want also to point back, since you are relying on the entire record, the prior order does reference trips volume. So I just want to make sure that,
As in trip traffic.
well, and you can, I just
different one.
wanted to, if it isn't here, I just want to make sure that,
Well, we're talking here volume of sales, rentals, whatever. Like, this is talking about volume and type of sales, retail, wholesale, et cetera. So it's talking about how much business they're doing, turning over, how many vehicles they're turning over, if they have 100, if they have 200, if they have 3, it doesn't really seem to be relevant, the number of vehicles.
And Ms. Turner's answer to the question by opposing counsel there, when asked about that, Ms. Turner's answer was rentals.
Right, yes, rentals.
Any other comments about A?
No, I would agree.
Yeah, we don't know, and I don't see where it's relevant.
About volume, you mean?
About volume.
About volume.
Correct.
Now, type is a different conversation, right? That just, again, it falls back to what do we define as rental? What does rental mean? Because that's what's defined in the listed use is a rental, sales and rentals.
Well, in that first point, there's et cetera. Rentals could be included within that.
Right.
My take on it would be A was considered. Volume is not relevant, but sales, retail, and wholesale sales are not allowed in single-family residential. So therefore, that was the consideration.
Yeah, I would agree with that.
Any other comments on A? All right, we'll go ahead to B. The size and type of items sold and nature of inventory on the premises. Ms. Turner's answer to the question that was asked by opposing counsel was vehicles were stored on the property. Inventory, I would assume, would mean vehicles or number of vehicles on the premises.
Available to rent.
Right.
Yep. And by the testimony in the previous record, the Turo website showed 3 vehicles.
Correct.
Any other comments about B?
No.
Ryder?
Well, the size of the items is obvious. They're cars, Jeeps.
so I guess my question about the number is your prior order, finding of fact number 16 says appellant has 9 vehicles stored at her property parked on various surfaces, including sand and dirt. So, I guess this is my caution to you as legal counsel is you're saying there's 3. Your prior order says
Well,
9.
we were just going by the testimony from tonight where they said there
You
was,
don't know whether that's
there's
true or
3 at the time that the notice of violation was issued.
Okay.
Any other
Yeah.
Any other comments about B?
No?
All right, we'll move on to C. Any processing done on the premise, including assembly, manufacturing, warehousing, shipping, and distribution. And Ms. Turner said that was not a consideration.
Yeah, I don't think that's relevant to,
I don't think that's relevant as well.
yeah, the use types comparison.
Shay?
I would agree. I would say they staff more than likely considered it, but none of these activities were occurring.
Thank you. And you, Robin?
So, I'm sorry, I just want to make sure I understand. So your discussion right now is just on what the testimony was tonight. You're not talking about the applicability of these factors to the other things you've already.
Nope, we're talking about
That's the purpose of
the
this hearing.
the
was to
applicability of these things to
hone
the
in
the
on the
use
13.
the use that we're discussing tonight.
From what you heard tonight, you're not considering the things you've already found and heard in your prior order that
I doubt
are
I could
relevant.
remember all of those things if I wanted to. I can remember tonight.
When I'm speaking that these things were considered, I would think that they were considered in the previous
Yes.
determination. So as you're saying, the whole package, not necessarily what we heard tonight, but including that.
Well, I went back and reread, the minutes from that, and so no, I'm taking in consideration what we heard in the first hearing, okay? I'm also, besides what we heard tonight.
That's our duty, is to see everything that has already happened. This opportunity is for them to present other evidence, both sides.
Additional.
That's what we came here and that's what we're doing.
Okay.
Any other comments on C?
No, none here.
Okay. On D, any dangerous, hazardous, toxic, or explosive materials used in the processing. Ms. Turner did say that that was not a consideration, although she looked at it.
Yeah,
It
I would
was
say
not
that,
occurring.
yeah, I would say that that characteristic is not relevant to this comparison.
Well, I would say with maybe the exception of the fact that the gas is flammable and explosive, and all those vehicles had that in it, however many of the vehicles there were.
Yeah,
It had not involved in processing, but they was there
right.
more than you would have in a typical home park.
But I don't know that, I don't know that
I
that
wouldn't
was,
use that
that
word.
was, I don't know that that was
I don't think it was considered
part
by
of
staff.
the citation
Okay.
issued for the
No, it
NOV.
wasn't considered by staff.
I think the NOV was for the use.
Right.
And that aspect of it, I don't think was part of the NOV. And, and I don't think it's particularly relevant to the actual NOV. Now, it might be an issue in real life, but I don't think it's,
Didn't say it was, just said
yeah,
it's a possibility.
relevant in this comparison.
Any other comments on D? Hearing none, we'll move on. E, the nature and location of storage and outdoor display of merchandise, whether enclosed, open inside or outside the principal building. Predominant types of items stored such as business vehicles, work in process, inventory and merchandise, construction materials, scrap and junk, and raw materials including liquids and powders. Ms. Turner mentioned, when asked by opposing counsel, that vehicles were parked in the driveway on that particular question. Meaning the display of merchandise.
You could make an argument, based on what I heard tonight, that they may not have been physically displayed
Right.
in a way that showed they were for rent. But when you when you go back to the website, you know, that's a virtual storefront, right? You're advertising.
Yep.
Exactly.
So it doesn't necessarily need to be stored in a way for sale or rent.
And Ms. Turner also mentioned, when asked about the predominant types of items stored, she mentioned the word vehicles.
Right.
Any other comments about E?
No.
All right, we'll move on to F, the type, size, and nature of buildings and structures.
I don't think that's really relevant here unless it's to make the case that it's a residential dwelling and this use is prohibited in a residential zone. But, you know, when you're talking about an online presence, you know, the type, size, and nature of the buildings and structures is really not relevant to whether it's a rental or a sales operation.
And Ms. Turner testified that that really wasn't a consideration. Is that correct?
Say that again?
Ms. Turner testified that that was not one of the considerations.
I recall her testimony to be, and I mean, you have to recall her testimony, but, and counsel, interject if you feel like I'm reciting the testimony inaccurately. I recall her testimony to be that she noted it that the structure was residential. That's the only thing I heard in regards to that factor. Does counsel, do you agree that that's the testimony?
Yes.
Any other comments about F? We all agree it's residential.
Yeah, and keep in mind too, as we talked about earlier, you know, because we don't have a definition, or a definition hasn't been established of a typical automobile rental operation. These types of comparisons, you know, it almost makes them inherently irrelevant because you don't have a baseline to compare to.
Exactly. There is no typical. You got
Right.
Atlanta International Airport.
Right.
And then you have mom and pop with 5 cars, you know, on the side of the road.
Right. So, I mean, you talk about the type, size, and nature of buildings and structures. What are you comparing that to? You know, you're talking about the underlying use,
Exactly.
right? So it's really hard to make some of these comparisons. Even going to the next one, G, you know, when we go to G, it'll probably, you know, same thing, you know.
Is everyone okay with F now?
Yep.
It's just a residential
So,
structure.
When you
Yeah.
say you're the comparison, and I think this is, you know, again, where this hearing is hairy, because it's just on these factors. We were not going back and start having a whole new hearing, but the staff determined that this use was most similar to car use rental sales, which I believe Ms. Farmer noted was in 10.5.
Yes.
And that was in the prior record. And so,
I think it's 10.4.5. Is it in 10.5 or
I think
10.4.5?
10.5 is
10.5.
definitions.
Yeah.
Did either of you bring copies of that?
I have a copy.
Okay. Did you bring any extra copies?
10.5 or 10.
The definition of,
No, I just have the UDO.
How big is the UDO?
do you want the,
So we don't have a
this
copy.
definition was previously entered into evidence?
Yeah.
So,
Not just tonight, but for going forward.
Yeah.
and it's very short, so I can just read it. Automotive sales and rentals, premises on which new or used passenger automobiles, trailers, recreational vehicles, or light trucks in operating condition are displayed for sale, lease, or rental.
Thank you.
That's the definition. But if you go to 10.4.5, it has the use classifications and use categories. Which is the use classification. It's not the definition you're comparing to. You're comparing to the use classification because you're trying to, the county's made the determination that this activity is most similar to this listed use, right? So the use classification would be the appropriate comparison, right?
Where are you looking at the use classification?
It's in section 10.4.5, commercial use classification. And it's, it goes back to the beginning of section 10.4.1, where I talked about in the beginning, where it defines principal use characteristics and examples. And then if you go to the principal use classifications, it lists the characteristics associated with that principal use, and then it gives examples of what that principal use is. And that's why I was mentioning an example of this use type includes automotive sales or rentals, including the sales and rental of automobiles, motorcycles, and light trucks. So that's all it says. It doesn't, that's the use classification. That's the listed use classification. So if we're making a determination that the unlisted use is most similar to the listed use, then we need to be able to compare these standards to the listed use.
So are you saying you agree with 10.4.5 as that is the most similar
But 10 point
as Young's situation?
vehicle sales and light vehicle sales and services. Yes, because when it gets to examples under that category, it says rentals, automotive sales and rentals.
And I think, and I'll just go back to the notice of violation that was issued. It is in violation of the use table for automobile sales and rentals. So it's talking about the use table category 4.1.1A.
Right. Yeah, and in 10.4.1 B1 general, it says this section identifies each of the 5 use classifications in table 4.1.1A summary use table and includes a section under each use classification identifying each use category. There are characteristics and examples subsections under each use category. And that's what I was just reading from. Characteristics and examples, which ties back to the NOV. Correct. Table 4.4.1A. All right.
Any other comments about F?
No, I think,
Problem?
No.
Okay.
nope.
All right, we'll move on to G. The number and density of employees and customers per unit area of site in relation to business hours and employment shifts. Ms. Young stated in her comments when asked on direct examination, she mentioned that users came to her home at some times.
It's another one I don't think is relevant because the listed use doesn't define a number or density of employees. It just defines an activity.
Any comments?
No, none on that.
I would agree with your original statement that she did testify that in the off-season, once in a while, customers come to the house. would say that that was considered by staff as well.
Any other comments, Troy, on that
No,
particular one?
no, I agree with that. That's a good point.
Everyone good on H,
Yes.
or G, rather?
I thought it was G.
Yep. We're ready to move to H now? Mm-hmm. All right, H, transportation requirements, including the modal split for people and freight by volume, type, and characteristic of traffic generations to and from the site.
We've heard that traffic is generated by this business. At times they come to the house to rent the vehicle, so you're creating traffic that way.
And Ms. Jenny mentioned in her answer towards cross-examination that vehicles were driving from the house that were rentals. Any comments about H?
Other than I'm sure it was considered by staff for the reasons it states. Traffic generation.
Troy?
Yeah, yeah, I agree with Shay. Again, like I was saying, what is a typical, what would you expect for a typical automobile rental? There's not a typical. So, I keep falling back to the basic nature of the activity.
There's just
And
similar.
would the activity generate traffic in that neighborhood?
If it were rented, yes.
A
Rented, it
similar
might just sit there.
business would create
Generates
traffic.
traffic, whether they're delivering the rental to
Yeah.
the customer, whether the customer's
Or
coming to
returning
them.
back.
It's
Right.
generating traffic.
Any other comments about that? H?
No, I don't think so.
All right, we'll move on to I, trip purposes and whether trip purposes can be shared by other use types on the site. Now, I don't believe Ms. Jenny had mentioned that was a factor, although they considered it. Lauren, you had mentioned about trips earlier. Did you find that area you were looking?
I'm not, I'm trying to put my hand on it. I would probably have to go through the transcript from the prior hearing. I know that, that was one of the things that the board discussed at the last, and your deliberations at the prior, hearing. And so I can, I think earlier you told me you're taking into, one, you can't remember everything tonight that you had previously heard and just did, but that you were including all of your prior to tonight. And so I can try to go through and put my hand on it, or I can put my hand on it and put it in the order, proposed order to you, and you can decide, and I'll point to where it came from in the record so everybody can know where I found it, to support that. If that's a relevant factor to you, then I will locate it and include it. Because there were a couple things in the transcript that you guys raised particularly before.
Any other discussion on I?
No.
And to be clear, I believe it referenced trips. If I don't bring it back to you, then just ignore what I'm saying, but I believe it did. And if I put it in there, I will try to tie it to a specific section so everybody knows where it came from.
Well, you could say, trip purposes. You talk about trip purposes. Now, Ms. Young did mention that she occasionally drove those vehicles or drives those vehicles herself. So taking those trips out of the equation, what would be the purpose of the other trips? Are the other trips for the purpose of rental activities?
That may very well be what was discussed previously about the trip purposes, not necessarily owner-driven purposes, but
Right.
rental-driven purposes.
Right, so it says trip purposes and whether trip purposes can be shared by other use types on the site. So if you take out the personal use of the vehicles and you focus on the rental use of the vehicles, then the rental use is the trip purpose, correct?
Well, they can be used for anything.
Yeah,
But-
yeah,
We've already heard testimony that they deliver vehicles to people sometimes
right,
for rentals.
That's a purpose as well.
That's a purpose.
yeah.
Any other comments on I?
No, I think I'm good.
Okay.
All right. We'll move on to J. Parking requirements, turnover and generation, ratio of the number of spaces required per unit area or activity.
That's another one that I don't really know that's relevant in making a determination of whether something is a rental business or not, because, then that starts getting back to the question of volume again,
Exactly.
right? And we don't have a definition of what the typical volume is. There's not a definition.
Nor do we know what they did.
Right. So again, it falls back to the activity. What is the underlying activity?
Ms. Young mentioned in an answer under direct examination that she does not allow users to park at her home when asked that particular question.
Yeah, but I'm not sure that that's relevant to whether vehicles are
No, I'm
being
just
rented
mentioning
or
the
not. Yeah,
comments
yeah,
she made. Any relevant comments I wrote down?
right.
Or should I say relevant or irrelevant?
Right. Right. I think either each one of these questions should be viewed, these standards should be viewed on the relevance to whether something constitutes a rental activity or not.
And it goes for parking requirements. I guess it actually is how many vehicles are you renting from the driveway or your property? It's owner-based requirement, not necessarily county-based.
Right.
Again, that's not really relevant to what we decide.
Right.
Right.
Any other comments on J?
I would say that it was definitely taken into consideration with the parking requirements and such as a comparison to, has been used here, similar businesses. She may have only had 3 cars, but if you allow this as a precedent, someone next may have 20. And now you've got
That's
an
not what we're
issue.
ruling on, though. When you rent a house up in Crawley, you could park 50 vehicles there if
That's an observation.
know.
know.
Rental properties, they don't necessarily do a good job at it, but they do try to regulate how many cars you park at that house. So you're not in the street nor on your neighbor.
And you drive by on a Monday in July, and nobody's paying attention to that.
Well, I think that in regards to parking requirements, I think you have to consider, again, what you're considering is the applicability or non-applicability of that factor to the comparison of the use Ms. Young was engaged in versus the use in the UDO.
Yeah, I mean, I don't think it's really relevant in that comparison. Like I said, is the use listed in the UDO doesn't have a volume attachment to it, yeah.
Any other comments about J?
Nope.
Roy?
No, I'm good.
All right, we'll move on to K, the amount and nature of any nuisances generated on the premises, including but not limited to noise, smoke, odor, glare, vibration, radiation, and fumes. I don't believe that is a relevant topic, as there appear to have been no occurrences of such items.
I mean, obviously, cars put out fumes, but
Yeah.
again, not relevant because we don't know the volume, and that's not
Right.
the issue.
But my recollection was that there were complaints.
But we didn't hear the nature of the complaints, did we?
I thought we did in
Only
the,
had one person speak
yeah,
at the prior one.
yeah.
There were 3 people who attended and only one spoke.
I would say it was probably considered by staff, but again, probably went back to traffic. If traffic was considered a nuisance. If there was.
Yeah, and I'd have to defer back to the county on the, my recollection was that a complaint was the driving factor from the original NOV. But I don't have the nature of that complaint in front of me.
That was Mr. Hubeck. Hubeck. He was the person that came forward at the last hearing.
Yeah, but I don't know that he was
He wasn't
the initiator
expert,
of the original
but just a concerned citizen.
complaint. Yeah,
And
Right,
being-
and my recollection is that again, that kind of funky procedural setup by the county, and I know you guys do it in your kind of opening statements generally, but those public comments aren't,
They're not
which is why it
witnesses.
wasn't in there in
Right.
your order, because that's not what's,
right.
you know,
We didn't rely upon any testimony they
correct.
did
That's
because they're not
right.
experts.
So anything regarding that factor would have come from staff or Ms. Young.
Yeah, and I
Or
wasn't
staff's
referring
investigation.
to that testimony. I was kind of going back to the beginning, the
Okay.
initiate of the NOV. My understanding was that was driven by complaint.
My recollection is that I know there was, and we can certainly refer to the record. I'll make a note about that particularly, but I know that in the record, the initial underlying first hearing record, there was staff report in great length about, you know, the complaint that came in, their investigation, what constituted the investigation, what they found in their investigation, and so you're probably recalling some of that. So,
Right.
and I don't want to misspeak because it's been 2 years. So, but again, I'll certainly note that and bring it back and for your consideration and review. And certainly in the interim, just as you guys are talking about these factors, and because you know I'm going to bring you an order back, is that if between tonight and when that order comes back to you, you review the record and there's something in the proposed order that you don't see that you considered, please note it, flag it where it's in the record, where you found it, and then bring that to my attention so that it can be discussed amongst the board as to whether it's a consideration or not. So we just want to make sure the record's clear about what you guys considered.
Right.
Any other comments about K?
I think I'm good, Shay.
Robin?
No.
Anything? Okay, we'll move on to L. Any special public utility requirements for serving the proposed use type, including but not limited to water supply, wastewater output, pre-treatment of waste and emissions required or recommended, and any significant power structures and communication towers or facilities.
I don't believe that had any effect.
I don't think it's
That was a
relevant.
factor, wasn't it?
Correct.
All right, we'll move on to M, this is the final one. The impact on adjacent lands created by the proposed use type, which should not be greater than that of other use types allowed in the zoning district. And Ms. Turner mentioned that there were few uses in SFO and very few commercial uses in SFO.
And I think that's one of the ones that gets me is, there are no other commercial uses allowed in single-family residential, so that's the basis of the whole complaint.
Yeah, and
Well, it
it's,
doesn't say commercial uses, it just says other types. You know, and again, I just don't see where that's really relevant because, you know, you could have, say there's 5 vehicles in that parking lot, they could be anything. They could be, people visiting, vehicles that belong to that people. That's not relevant. What is relevant is what they are doing with those vehicles. That's what we pointed out, which was renting them.
and that standard doesn't really define what impact means. What do we
Yeah,
mean
good
by
point, too.
impact? Or do we mean an environmental impact? Do we mean
Physical or
physical
financial?
impact? Or we,
Financial.
nuisance impact to the neighboring properties? It doesn't really say what that means. But it says, which should not be greater than that of other use types allowed in the zoning district. So the zoning district is residential. So, I think this one would really depend on how you define impact.
And it's not clear.
No, it's not
You
clear.
know, and I don't see the difference between having a fleet of rental cars and, having family get-togethers, people driving 10 cars into the property.
Right.
Or adjacent properties, not even specifically hers, any property along there.
So in the question of whether the proposed use type constitutes a vehicle rental, is this standard even relevant? I mean, you don't have to have an impact on an adjacent property for it to be a non-permitted use. Correct. In the district,
Again,
right? It
not really
doesn't, it
relevant.
doesn't have to be impactful. It just, has to be a use that's not allowed in that district.
Any other comments, Rob?
I'm done.
No, I'm done. I'm good.
Okay. Is there any other comments you'd like to make about any evidence we've seen tonight? Or anything in addition to the 13 points?
So in D3, it says unlisted use not permitted. So it says if after applying the criteria in section 10.4.1 D2 above, the director determines that a proposed unlisted use is not similar to a listed use, the proposed use shall be prohibited.
Well,
Doesn't make
Make any
Well,
sense.
It makes
well,
Exactly, I read that 5 times.
I want to point you back to your prior order, which, so it says that if after applying the criteria, it finds that the unlisted use is not similar to a listed use. It's not talking about the zoning district, it's talking about at all in the ordinance. Car use rental or car rental or
Right.
sales or whatever that section is, the zoning,
But if we think it is similar to a listed use, that's,
automobile sales and rentals, let me get this right, I'm sorry. Automobile sales and rentals, then it is a permitted use, right? So automobile sales and rentals is a permitted use in the ordinance. It's just permitted by special use permit and certain zoning districts. So,
Ms. Wample, may we clarify just for the record what 10.4 D2 says? Because we would slightly disagree with that interpretation. And we do agree it is confusing, which was the whole point of our appeal. The section that is at issue tonight is the standards for interpreting unlisted uses as permitted. And as it says, the director shall interpret an unlisted use as permitted in a particular zoning district only after determining that the nature, function, and duration of the use and the impact of allowing it in the zoning district are so similar to those of a use type or category allowable in the zoning district that the unlisted land use should be deemed allowable in the same manner as the similar use type or use category. So we would contend that it is directly connected to the zoning districts, in this case, the SFO district, which is residential. So whether or not car sharing is similar to a use that is allowable in the SFO. If it is, then it would be permitted. Then
Well-
under unlisted uses, if you were to find the unlisted use is not similar to a listed use, then it could be prohibited. Thank you.
So, and that's fine. I'm going to disagree with you. An unlisted use versus a listed use. And my recollection of the case law is that when it's a not listed use anywhere, it's not a permitted use anywhere in the ordinance, that the counties can, or towns cannot now just say, hey, we don't list it, you can't do it anymore. And I don't, my legal advice to this board is that that's not what this ordinance says. This ordinance says if it's found to be similar to a permitted use, which it is, then it's a permitted use within the zoning district in which it's permitted. I'm unaware of any case law or statute that requires a listed use to be permitted in every use district, or that the county has to list permitted and non-permitted uses for each specific use district, which is, the purpose of the use table. So I disagree. You've certainly noted it for the record. I understand it's the crux of your appeal, but it's clearly a permitted, automobile sales and rentals is clearly a permitted use in the ordinance in certain zoning districts.
And just in terms of relevant case law, as I had mentioned in my closing, Land v. Village of Wesley Chapel, the court held that unless an ordinance clearly prohibits a particular land use, that land use is allowed. And so we would disagree with that interpretation as well, just for the record.
Well, okay, I understand, and I guess you're saying that's because it's not automobile sales and rentals, it's car sharing. So your contention is that it's not automobiles and sales and rentals, and that it's car sharing, and that car sharing isn't listed anywhere in the ordinance.
Well, I think Ms. Turner testified that car sharing is an unlisted use that is not defined by the ordinance anywhere. And so that is why we went through this whole exercise to determine whether the unlisted use of car sharing is similar to the listed use automobile sales and rentals.
So the underlying order, and my understanding, Ms. Turner's testimony, is that car sharing was determined to be automobile sales and rentals, and that you can call it what you call it, car sharing, or loaning my car to my friend, or share riding, or whatever. But I mean, I understand your argument for the record, but my advice to the board, and they're asking for clarification about those two sections, my advice to the board is that this is not an unlisted, that the board, that staff determined that this use, consistent with D2, that it is a permitted use, but in certain areas of the county, under certain conditions.
And we would just note for the record, the purpose of this hearing was to look at 10.4D2, and D is entitled Interpretation of Unlisted Uses.
Okay, thank you.
Yeah, and when you talk about D2 unlisted uses, I mean, I read that, unlisted uses, I read that to say, it says that the use type, let's see, director shall interpret an unlisted land use as permitted in a particular zoning district only after determining that the nature, function, and duration of the use and the impact of allowing it in the zoning district are so similar to those of a use type or use category allowable in the zoning district that the unlisted land use should be deemed allowable. So it says right there that, if we're going to make a determination that it's similar to a listed use, it would have to be a listed use that's allowable in that district for the unlisted use to be allowable.
And I remember in our original ruling, we addressed that. Even though the term car sharing is unlisted, we determined that it was car rentals.
Correct. Right. Which gets back to the examples section in B3, 10.4.1B3, where it talks about the example subsection lists common examples of use types included in the respective use category. It says they are based on common meanings and not on what a specific use may call itself. So,
Any other comments about any of these 13 items?
So if we're focused on D2, going through those standards, making a determination of relevance of each one, does that require us to make another determination that this is substantially similar to an existing land use, or that's already in the
I
record?
think that, and I guess that was kind of the original discussion, and I think really you have to decide, is there anything that you heard tonight that changes your opinion about your prior decision? So I think you need to either affirm your decision or say,
Modify or
modify
reverse it.
any one of those three options. You can do any one of those three options that I read earlier. I think that's what both council are asking you to do. So, but again, I think, yes, but you can make one of those three based on their request.
I'm going to ask a question to each of you, unless you have any other comments about any of these.
No.
You have any other comments? Shay, do you believe we have thoroughly reviewed all 13 items?
Yes.
Troy, do you believe we have reviewed thoroughly all 13 items?
Yep, I do.
Robin, do you believe we have reviewed thoroughly all 13 items?
I do.
And I personally believe we have reviewed thoroughly all 13 items. We all can agree 100% on that, correct?
Yep.
Were there any other comments or discussion you'd like to make?
Before we get into affirmation or discussion, no, I don't have anything further.
How about you, Shay?
Nope, I'm good.
Robin, how about you? Okay, so our purpose tonight is going to be to either one of these three items We will affirm our prior decision. We will make a modification to our prior decision based on new information we received tonight, or we will make a reversal of our prior decision. Does everybody understand that?
Yes.
Am I correct? All right. I'll be happy to accept any motions now if one of you would like to make one.
I make the motion, we affirm our previous decision.
I'll second that motion with the stipulation that we have entered into the record tonight's discussion and evaluation of the 13 standards.
Say that again.
What we just did.
What's that?
Isn't that what we just did?
Yeah.
Okay.
So, yes, I mean, this documents, your deliberation documents into the record, and ultimately the final, we would memorialize your consideration, and I guess the function by what you did based on Judge Tillett's kind of multiple options he gave you to apply to send him a new order. So, I think you have tonight's deliberation and then obviously the entire record.
Right. All right, scratch that second, and I will second the original motion.
Okay, we have a motion to affirm our prior decision. We also have a second. Is there any discussion?
Nope, I'm good.
All right, we'll now take a vote. All those in favor say aye to affirm. Aye. All opposed say nay. The motion carries unanimously.
And so now I would ask you to, I had alluded to this earlier when we were, regardless of your decision tonight, your proposed order, because this was a remand specifically related to your findings. And I know there were some things when you were going into further discussion tonight about the factors where you referenced the prior record. Judge Tillett's order specifically gave you the ability to consider and rely solely on that, or to supplement with an additional hearing. So I would prefer to bring the proposed draft order back to the board for your consideration. And then, of course, if there was anything else particularly in the record that you felt was particularly relevant to you that you didn't see in the proposed order, please bring that. I'll be sure, counsel, that anything I put in, I'll note where it is in the record such that you can see that and the board can see that. So we can try to, and I will send it. What I will do is send it to council first and attempt to narrow the issues before I bring it to you guys. And then maybe we can address the board's additions or changes kind of at that time, and we can try to work through what we need to work through in advance. So I'll do that first and then bring it to you. In terms of scheduling for that, do you guys just want to circle back about availability to do that, or do you want to set a date tonight?
So would it just be that we work on the order over the next 30 days and then it's before them at their next?
Well, yeah, that's what I'm asking. If I wasn't sure what your availability was to return to the next hearing. When is
It is
our
the next
July hearing? Or July date? I'm on secured leave the second week of July. And if it's the second week of July, that might be a barrier.
July 11th.
I'm going to be on secured leave, so we can't do, I don't feel like I can pass this off.
So maybe August, what would be the August meeting?
Be August 8th.
That's fine with me.
Is August 8th agreeable? Okay, so we will plan to bring you a draft August 8th. And then certainly by then, ideally, we'll have narrowed any of our disagreements. And then we can just kind of address anything you have in addition. But it's important that if you have something else that you tag it in the record, because we've got to be able to track for appeal purposes where you got what you're asking to be added or changed in the order. So
So understanding you correctly, we will receive a copy of that prior to the meeting,
Correct.
correct?
Yes, you will.
All right,
Yes.
very good.
Is the discussion of the order in the August meeting, is that in closed session or is that?
No, I would think that would be open session unless they had a,
That's what I would think too.
no,
I just-
no, unless they had a
like a-
procedural question. No, I mean, to me, that's any kind of further deliberation about that. So unless they had a legal question, I would not do that in closed session. I think it'd be appropriate to be in open session.
Attorney Cook asked what I was getting ready to ask. She ready to
Well,
ask
I mean, the board
exact
always.
same question.
The board can always ask to go into closed session regarding, questions of, I think, legal, technical questions, procedural questions, but anything that has to do in relation to deliberation, consideration of evidence, or things like that, that has to be done in open session and documented on the record.
Chair McCraddock and I may have been thinking about the deliberation about what to do in response to Judge Tillett's order, which was in closed session.
Okay,
So, but in the open is fine by me.
okay. I think that unless they had a question about a legal term or something like that, they could technically go in for attorney-client privilege, but I think that if they're trying to put findings, it's, further, I think it needs to be in open, particularly
Yeah.
for appeal,
All right.
so.
Are there any other announcements for tonight's meeting? All right, I'll take a motion to adjourn, please.
I'll motion to adjourn.
And I'll second that.
We have Shay and Robin. All those in favor say aye.
Aye.
All opposed, nay. The motion carries unanimously. Be officially over.